sorry for troubling one matter. It is, if it is permissible for the court, can I move an unlisted matter? Is regarding settlement of a fishery, which has been settled on 28th of this month, 29, 30, 31st a holiday. First, we got the certified copy of the settlement order. Second, we prepared and we have filed it, and we have got the writ petition number also. If it is possible at 2 o'clock, my lord, because position again, it takes very difficult, my lord. They are not there. I'm deeply obliged.
May I please? So with the consent of the petitioner, I beg to mention item number 15, Lordship. On behalf of Mr. S.S. Roberts. So we are supposed to get instruction, but instruction not received. So immediately after view vacation, Lordship.
Yeah, bring on behalf of
S.S. Roberts, yes.
And date may be fixed,
Yes.
madam. I am not a petitioner.
Oh, after Bihu, Lord.
For a petitioner. Date may be fixed, madam, after petition.
Okay. But
20
Mr. S.
Yes,
Bhatt
Bhatt.
on the council
24.
on request made by Mr. Edeka.
Yeah.
You have 40?
On behalf of SSR for CGSC. Lord.
Appearing on behalf of Mr. S. Okay, then don't say on request made on behalf of SS.
Yes,
Then not CG.
And 24th, Lord.
24th.
24th, Lord.
Okay.
Deeply obliged.
May it please your lordship. With an apology, Miller. I'm yet to file a writ petition or about to file a writ petition, Miller. My colleague could come late, so I could not serve the copy and hence the delay. The difficulty is I ran a wine shop, Miller, and there has to be a move to shift from place A to place B. Around 5 lakhs what I have paid. No difficulty. Until the commissioner level of Assam, all cleared for shifting. But they are not letting me operate. And now the exigency is there's a move afoot to suspend or cancel. If that goes, everything goes. And the larger issue is that if the persons who actually are consumers, they get a chance to move and associate with others, then my business also fails. Nothing remains.
That's a different
That's a different issue, but this is coming in the way. This is coming in the way. Therefore, on the suspension part, I'm a little bit under anguish. May I pray at 2 o'clock? We'll be fighting and getting it done.
Okay, if you can get it done.
Absolutely.
we'll take up advance.
May I please, your lordship, I would like to mention listing writ petition, lordship. Similar matter has been listed on tomorrow, lordship, daily list, lordship, number 5. I have show cause and recovery notice was challenged, lordship, against the IOCL, lordship. IOCL is show cause and recovery notice. So may I please, lordship, list that along with that matter, lordship, tomorrow, lordship.
Tomorrow is listed.
Yes, lordship.
May it please, your lordship. Lordship, I beg to mention item number 9, lordship.
Yes.
Lordship, respondent has filed, lordship, affidavit opposition, lordship. Lordship, 2 weeks time may be given to file reply, lordship.
Okay, Mr. A. Sharma.
My lord, I have refused. My lord, let the time come, my lord. So on the last occasion, my lord had given him 2 options, either to withdraw or dismiss it.
Okay.
Petitioner filed to reply, lordship.
Let us see. Wait for you.
Item 1 of daily motion.
May I please, your lordship.
Hmm.
This is regarding that market case, lordship, Hing market, where the H7 was given the settlement.
May I just pray for taking up this matter after a while, right?
Where?
But I'm led by Mr. Tain Chaudhary,
Hmm.
legs. After some time.
Hing municipality is here. I think he is represented by my friend. Now, the only issue that was there a private meeting wherein this issue was discussed. And they were saying that on 9th, there was a private meeting. I have taken my instructions, lordship. On 11th, there was a meeting, but the purpose of the meeting was for extension of the date of last submission because it was on 12th. 12th was the last date. On 11th, there was a meeting held wherein the issue was only for extension. And interestingly, there is no minutes of that meeting. So
Okay.
therefore,
Wait for some time.
yes, your lordship.
2 and 3, admission, part 3rd matter.
Where's Goswami? The other day he took some time. Anyway, you can proceed.
First, I'm coming, my lord, Assam Minor Mineral Concession Rule 2013, my lord. This book, my lord.
You're the standing counsel.
Of AAC, my lord. Well, page 245, my lord, Assam Minor Mineral Concession Rule 2013.
Page,
Page 245.
yes.
My lord, definition is section 2E, competent authority, my lord.
Hmm.
The competent authority means the Director of Geology and Mining, Assam, in respect of minor minerals as listed in Schedule X. In respect of Schedule X, my lord, Director, or the Principal Chief Conservator of Forest and Head of Forest Force, Assam, in respect of minor minerals as listed in Schedule Y. So, my lord, what is the Schedule Y, my lord? That has been mentioned, my lord. That is in the that is in page 363, my lord.
Yes.
Schedule Y. That, my lord, column, my lord, 4, my lord. Schedule, page 363, Schedule Y, my lord, boulder, my lord. That is under Schedule Y. So, my lord, Principal Chief Conservator of Forest is the, my lord, the competent authority, my lord. And in respect of, my lord, Rule 3.2, my lord, then lordship may come to page 248. Rule 3, my lord.
Yes.
My lord, power to grant mining lease or mining contract or any other concession or license or transit pass or permit, etc. A mining lease or a mining contract or permit or transit pass or license or control regulation of mining or other actions under this rule shall be granted by Director of in respect of Schedule X and the Principal Chief Conservator B, my lord, Principal Chief Conservator of Forest and Head of Forest Force Assam or any officer authorized by the government. That is the word, my lord, by notification in this behalf in respect of minor minerals for uses other than industry as specified in Schedule Y. So, my lord, in this particular case, my lord, my lord, we have, my lord, forest is a transferred subject, my lord, and the government by way of notification and in, my lord, after resolution, adoption of resolution in the Assam Legislative Assembly, my lord, issued the notification, my lord, under the constitution, my lord. So that is in the page 7 to 9, my lord.
Yes.
Page 7 to 9. That is a notification dated 29 June 1995.
Yes.
My lord, I'm reading it, my lord. Pursuant to the resolution adopted in the Assam Legislative Assembly on 20th April 1995 and the memorandum of understanding reached between the Chief Minister of Assam, Autonomous State Demand Committee, Karbi Suenjo, New Delhi, in presence of the Union Home Minister, the Governor of Assam, in exercise of the power conferred by subpara 2 of paragraph 6 of the 6th schedule of the Constitution of India and with the consent of the Karbi Anglong Autonomous District Council is pleased to entrust and delegate the function in relation to the following subjects departments to which the executive power of the state of Assam extends to the Karbi Anglong Autonomous District Council with effect from the date of its publication in the official gazette. So, my lord, the forest is the, my lord, serial number 3, my lord.
Yes.
So, my lord, your lord, if you lordship look into the provisions of the 6th schedule, my lord, 6th schedule empowers the, my lord, extends the power to the autonomous council by way of resolution in the assembly, my lord. Accordingly, forest is the transferred subject and the executive power state of Assam extends to the autonomous council. So, the autonomous council have the power. My lord, in this case, my lord, notification was also issued, my lord, in this particular case, permit was issued by the divisional forest officer, my lord. So the permit, who issued the permit, he has the authority to cancel it also. And the government of Assam also issued the notification, my lord, the providing the power. Well, this is a notification issue. Lordship asked the notification, my lord. This is the notification, my lord. Well, in exercise of the power conferred under Rule 2(1)(e) and Rule 3(b) of the Assam Minor Mineral Concession Rule 2013, and for smooth functioning of the field level activities, the divisional forest officer of the concerned divisions are hereby declared as the competent authority, my lord, to execute various provisions of Assam Minor Mineral Concession Rule 2013 in respect of Schedule Y. They will, however, obtain approval from the respective senior officers as per Delegation of Financial Power Rule 1999 as and where required. My lord, so the divisional forest officer is the competent authority for issuance of the permit, and if he has the power to issue the permit, he has the power to cancel, suspend it also, cancel it also, my lord. That is my lord, first point, my lord. My lord, so we have the power of the state to execute, my lord. So lordship, now into, my lord, we are exercising power on this rule, Rule 3811, my lord. That is in the page, my lord, page 268, my lord, chapter 7. Rule 38 is the conditions of the mining lease contract, my lord. The relevant, my lord, we are exercising power Rule 3811, my lord. Page 271. Page 271, 11, my lord. So power of suspension, my lord. Where the continuance of mining operation in any area, in the opinion of the state government, is likely to endanger the safety of any national or state highways, road, bridge, drainage, reservoir tank, canal, or other public works, or public or private building, or any other public interest, or that is important, my lord, or in the interest of environment and ecology of the area. So we are invoking that power. In the interest of environment, ecology of the area, the government may suspend the operation in the entire concession area or part thereof with immediate effect by communicating the regions thereof in writing. The government may, whatever so warranted, terminate such mining lease contract over entire area or part thereof after giving 60 days notice to the concession holder in his behalf, and the grant of such mineral concession shall stand terminated from the date specified in the said notice.
Let us see the notice.
Sir, termination, my lord, we have not yet issued any notice for termination.
No,
So-
the impugned order.
So, my lord, impugned order, my lord, that is annexed, my lord, in the repetition, my lord. Page 34, my lord. Page 33 in the first case. In pursuance to the above, the mining operation is suspended with immediate effect. That is only the suspension, not the termination, my lord. So we have not issued the 60-day notice. Thereafter, it is equal to be issued with immediate effect under Parku Pahar Range jurisdiction for the stone quarries falling under the proposed, that is important, my lord, proposed eco-sensitive zone of Kaziranga National Park and Tiger Reserve, and with default eco-sensitive zone of KNP and TR in compliance of the Supreme Court's order in this regard. So we are issuing this order, my lord, in compliance of the order passed by the Honorable Supreme Court regarding, my lord, mining operation in the Kaziranga National Park in a boundary, and my lord, that it is under the proposed eco-sensitive zone, my lord. So the power, we have accessing that power for issuing of the for suspension, and we will required to be issued notice of 60 days or before termination. So the petitioner will get an opportunity, my lord, to place their views, my lord, before the authority, my lord. And this is order is not for, it should not for the violation of any terms and conditions, my lord. If for violation of the terms and conditions are there, then the for suspension also it is required, notice is required to be issued. But it is, we're exercising power under 38(11), my lord. So for termination, 60 days notice is required. Now I am coming to the order of the Supreme Court, my lord. On the lordship, my senior friend has also, senior advocate has also relied that particular judgment. We are also relying that particular judgment. 2022, my lord. 2022 10 SCC 544.
Yes.
Lordship, we are going to the, my lord, relevant paragraph which we have, my lord, we are relying, my lord. Earlier that paragraph, my lord, the 577, my lord, page. Paragraph 56, my lord.
Yes.
56.1, that has already been modified, my lord. My senior colleague, my senior friend has, senior advocate has already referred to that. 56.1 and 56.4, my lord, that has been modified in the by judgment dated 26/4/2023. We are relying 56.2, my lord. That has not been, my lord, modified, my lord, or my lord. In the event, however, the eco-sensitive zone is already prescribed as per law that goes beyond 1 kilometer buffer zone. The wider margin of eco-sensitive zone shall prevail. If, my lord, it is beyond 1 kilometer, what is the proposed eco-sensitive zone, my lord, that will prevail. If such wider buffer zone beyond 1 kilometer is proposed under any statutory instrument for a particular national park or wildlife sanctuary, awaiting final decision in that regard. If the decision has not been taken by the central government also, what are the proposal we have submitted, state government submitted to the, my lord, Ministry of Environment, Forest and Climate Change, that will prevail, my lord. Then till such final decision is taken, well, that is a specific word, then till such final decision is taken, the eco-sensitive zone covering the area beyond 1 kilometer as proposed shall be maintained. So it is not like that, it is only the 1 kilometer pan-India. So the Supreme Court issued it, but when the proposal was submitted to the ministry, my lord, central government, whatever in the proposal it is there, it should prevail, my lord. That is the direction. We are relying on that judgment, my lord. And before that, another point, my lord, lordship rule 67. I am again coming to the rule 67, my lord. So if the petitioner have any grievances, there is a provisions for review, my lord. 67, my lord. Rule 67. Page 289. Okay. The director, principal chief conservator of forest and head of forest force Assam may either on an application from an aggrieved party, in this case the petitioner is the aggrieved party, or on his own motion review the orders passed by him under these rules in any matter. In this case, my lord, the divisional forest officer is the competent authority. He has also the power of review, but he is working under the autonomous council. So the council can also review the order, my lord, which we have issued as part of, my lord, whatever the file submitted to us by the director of Kaziranga National Park, my lord. We wrote to the director of Kaziranga National Park to submit the proposed eco-sensitive map, my lord. He has submitted to us and we have annexed it to that also, my lord. If it is any contradiction is there also, it can be reviewed, my lord. So if the petitioner submit an application for review, we'll consider it within, my lord, 10 days and we'll dispose of it, my lord. And if the petitioner is also wants an opportunity of hearing, my lord, that can also be, though it is not provided under the rule, my lord. But before termination, definitely petitioner will get an opportunity of hearing. But for review, my lord, Lordship may remitted back the matter to the autonomous council also, so that we can review it, my lord. That is under submission, my lord. But another point is there, my lord, regarding which I am referring, my lord, to
Who's the reviewing authority according to you?
yes, my lord. Reviewing authority is the, my lord, we have already pointed out the executive power state of Assam is extended to the Karbi Anglong Autonomous Council under, my lord, notification, my lord. So it can be remitted to the Autonomous Council, my lord, as the meeting is presided by the chief executive member of the Autonomous Council, head of the council, my lord. So the, my lord, it can be reviewed by that, my lord, if it is sent it back to the, my lord, Autonomous Council, it can be reviewed under exercising that power, my lord. Whatever the grievances the petitioner may have, they may submit it in writing. We'll consider it definitely, my lord, within a period of 15 days, my lord. There is a summation. But, my lord, regarding that also, my lord, another point is that Lordship will look into the, my lord, judgment dated 2013, 8 SCC, case 198. I'm giving the copy also, my lord. I said it. 2013, 8 SCC. But there. It is here. Okay. Yes. The 2013 HCC, my lord. The first paragraph, my lord, after hearing the council, second, it is submitted that till the central government constituted a statutory agency as contemplated by Section 3 of the Environment Protection Act, it is necessary and expedient that an authority be constituted by the national level to be called the Central Empowered Committee for monitoring or implementing the honorable court's order, and to place the non-compliance of cases before it, including in respect of encroachment, removal, implementation of working plans, compensatory afforestation, plantation, and other conservation issues. So the paragraph 1.4 is the, my lord, important for us, my lord. Paragraph 1.4.
Yes.
Any individual having any grievances against any steps taken by the government or any other authority in purported compliance with the orders passed by the Honorable High Court, which will be at liberty to move the committee for seeking suitable relief. The committee may dispose of such application in conformity with the orders passed by the Honorable Court. Any application which cannot be appropriately disposed of by the committee may be referred by it to this Honorable Court. So that if any individual have any grievances, my lord, against the closure of mining, they can approach the competent Central Empowered Committee, and the Central Empowered Committee cannot decide it, then it can be goes to the, my lord, Supreme Court, my lord. Relying on that judgment, my lord, division bench of this court, my lord. Decline to, my lord, interfere with my entertain the PI also, my lord. Well, two orders are there, my lord. And these two orders are there, my lord, but of the division bench, my lord, that if any have any grievances and it is the pending in the Supreme Court, so it should not be, and the PI has not been taken into consideration at that moment, my lord. So as the power of review is there, my lord, so my submission is the power of review and power of appeal. Both are there, 67 and 68, my lord. And this is the, my lord, division bench.
PIL is the same number.
PIL number 47, my lord. Same number, my lord. One PIL.
Oh.
First, the division bench consisting of the Chief Justice declined to accept it. When our matter was closed by the Supreme Court, then the PIL petitioner has already approached the court, my lord, again. Then they're referring to that judgment, my lord. The division bench, my lord, held that, my lord, as the matter is pending in the Supreme Court, and there is a Central Empowered Committee, my lord. So they should approach them. if the petitioner have any grievances. And regarding, my lord, mining permit, my lord.
It's not a disposed matter.
Well, that has not been disposed of, my lord, it is pending.
Hmm.
It's pending, my lord. But it refers, my lord, the judgment I have referred it, my lord.
Yes.
But that has been referred, my lord, in the order dated, my lord, 6/12/2024. So am I submitting it that is the Central Empowered Committee is the authority. My lord, if the petitioner have any grievances also individual, they can approach the also. But as per the rules, my lord, rule 67, power of review is there. So that if the petitioner submit an application for review, we'll definitely consider it, my lord, within a stipulated period, my lord. So, my lord, this is the mining plan, my lord, that which is the original document, my lord, the petitioner, my lord, entered with the agreement with us, my lord. And it has already been all the clauses are there, my lord. And if you lordship, that the particular format is there, my senior advocate, that has already been referred to, my lord, that format, my lord.
You have filed also.
We have filed, my lord, only to show that the mining permit was issued by the divisional forest officer. So as he has issued the mining permit, he has the power to, my lord, cancel it. For that purpose, we have issued the mining permit, my lord. But there are certain clauses are there for issuance of notice to before suspension. If any terms and conditions are violated, my lord, then the notice is required to be issued. If we issue the notice that there are certain terms and conditions have violated, so 15 days notice is required to be issued as per the format or as per the mining permit that he has agreed with us, my lord. The agreement executed with us, my lord. And it is the particular format that has been, my lord, in the piece. My lord, that is that model form is there, my lord, page 292. That is the agreement executed by us. We have annexed, my lord, in our affidavit, my lord. And page 303, my lord, but for rights of the state government.
License.
Part 4, rights of the state government. Suspension or terminate of the lease. 303. Agreement of there is a format agreement that executed with us, my lord. There is a format. The competent authority shall have the right to suspend or prematurely terminate the lease. These are the three conditions, my lord. If the dead rent or royalty or surface rent or any other amount due to the government are not paid, there is the first condition. If that condition is violated, then the notice is required to be issued. Second, if any terms and conditions of the lease deed or conditions or grant or permission to undertake mining by any other statutory authority or competent authority is violated. And third, if any of the provisions of these rules and other laws of both central and state government are applicable to mines and minerals are not complied with, provided that no order of suspension or terminate of the lease shall be passed by the competent authority without giving regional opportunity to show cause and following the procedure prescribed in the Assam Minor Mineral Rules 2013. So, my lord, for violation of these conditions, notice is required to be issued, but not for violation of environment and ecology as per Rule 3811. So, we are invoking the power under Rule 3811. So, if for violation and notice is required to be issued 60 days notice, my lord. So, we are required to issue 60 days notice before termination, my lord. Definitely, my lord, if the petitioner has not filed any application for review, will, my lord, go to the next stage, my lord, for my lord, termination of the lease. At this stage, my lord, there is no question of termination, only the suspension comes. And after giving an opportunity of hearing, my lord, then only the question of termination will come. And as per the, my lord, Supreme Court order, which we are relying, my lord, and it is in the proposed eco-sensitive zone. If the petitioner can establish that it is not under the proposed eco-sensitive zone, then automatically, my lord, it is the duty of the Autonomous Council to review it also, my lord. So, my lord, my prayer is that at this moment, Lordship may remit the back matter to the Autonomous Council to review it, and the petitioner may be directed file a detailed representation regarding their grievances, my lord. Definitely will consider within a particular period, my lord. Anytime, my lord, 10 days or 15 days, we can review it, my lord. These are my prayer, my lord. That is good.
My lord, we have filed an affidavit today, my lord, but due to certain, it could not come to record because it was filed just in the morning. Otherwise,
Which, your respondent?
respondent number, state government, my lord, state forest department. Yes, okay. Respondent number 485.
Okay. You file your affidavit in the morning?
Today it has been filed, my lord.
You've got a copy?
Copy has been served.
Last night. No?
7.
There's nothing in it.
But my lord, I have submitted all those documents they have submitted by the judgment 36/2002 that has been annexed in the, my lord, that particular affidavit, my lord. And they both are relying, state government also relying on that. We are also relying on that particular judgment, paragraph 56.2, my lord.
In our affidavit, my lord, we have contended that the matter may be remitted to the Central Empowered Committee, my lord. There they can give their
Both the contention are, my lord, they can, my lord, the contention of the state government is that it can be remitted back to the Central Empowered Committee to take the decision. Or the our contention is also that they may go to the Central Empowered Committee or for filing an application for review. It is up to the, my lord, petitioner may, my lord, take the reports of any of
You're
the.
appearing on behalf of R4 or BN Kosami is appearing?
on behalf of PN Goswami, my lord, but due to some difficulty, he could not appear today.
But where's the affidavit?
Affidavit filed today, my lord. If
You filed today,
today,
this morning?
this morning.
Then what do we do?
Nothing, Lord. The affidavit is here, your lordship can have a look. All judgments again incorporated and given, which we have cited, they have cited everything. It has gone to 300 pages, and the relevant thing is not mentioned at all. So let him say whatever he wants to say, but it will not help us in any way.
Okay. But then at least the affidavit should come on record.
They should have taken that step.
Earlier, you should have mentioned before Chutia started.
It can be fixed at 2, my lord. Then.
No, not at. We continue. Otherwise, this is going on like this, and there is nothing that is. We have our copy. We have handed over to the lordship. Because faith was not in the picture at all.
You're filing your affidavit quite late. actually.
I have completed my submission thereafter. They will.
You file your affidavit. Let it come on record.
Yes, yes.
We'll take up tomorrow.
No, my lord, let it come up on record. It doesn't matter. My lord. I will reply to what he has said. straight away.
Okay. Then you're going to argue the matter. Bhato. Get the affidavit then. Huh? Let it come. Yes, you can proceed then.
We have argued that the matter may be remitted to the Central Empowered Committee, my lord, because this whole exercise, this impugn notice is a result of a direction given by the Central Empowered Committee. And that might lead to, my lord, multiplicity of proceedings.
So you're appearing for
For an-
forest.
for
Your
state
good,
forest.
good name?
I bought a
Respondent Kiman
4 and 5.
are 4 and 5. Remand to CEC.
Okay. Anything else?
That is our contention, my lord, because it might lead to multiplicity of proceeding because issues regarding the eco-sensitive zone of Kaziranga National Park that is pending before Supreme Court. So, my lord, any observation by this honorable court, my lord, might cause multiplicity. That is why, my lord, it is best that they approach the Central Empowered Committee.
Okay.
As the state council has not, my lord, pointed out all those, my lord, is the state government. We have annexed all those documents in the affidavit. First, we'll look into our affidavit, my lord.
Where is your affidavit?
My lord, the first affidavit, my lord, my lord, 1003/2025, my lord.
1 minute. 1 minute.
Case number 1003/2000.
Yeah.
My lord, that page 36 to our, my lord, we are relaying the, my lord, order of the Supreme Court also there.
Mm.
My lord, just I'm going to directly, my lord, the Supreme Court's order, my lord. Which is applicable, my lord, direction to the, my lord, page 51 of our affidavit, my lord. Page. In, my lord, petitioner has also submitted that particular judgment, my lord. In view of the aforesaid, my lord, the last line, my lord. In view of the aforesaid, the first, my lord, that is the, my lord, report of the Central Empowered Committee. Consider the report of 6/2019, my lord. That is of the report of the, my lord, Central Empowered Committee. And that report is annexed by the state government in their affidavit opposition. That is in respect of 2019, my lord. And that on that basis of the report, my lord, Supreme Court passed the order, issued the direction to the Karbi Anglong Autonomous Council. What are the direction? That is the last paragraph. In view of the aforesaid, we order that all kind of mining, well, that is the word used by the Supreme Court, my lord, all kind of mining and related activities along the aforesaid Kaziranga National Park area and in the entire catchment area of rivers, streams, and rivulets originating in Karbi Anglong hill ranges and flowing into Kaziranga National Park, including tiger reserves, are restrained. My lord, the Supreme Court passed a specific order in respect of, my lord, Karbi Anglong Autonomous Council that all related activities along the aforesaid Kaziranga National Park area and in the entire catchment area of rivers, streams, and rivulets originating in Karbi Anglong hill ranges and flowing into Kaziranga National Park. And flowing into Kaziranga National Park, my lord. The rivers originating from Karbi Anglong Hill District and, my lord, flowing to Kaziranga National Park are restrained, my lord. And our affidavit, we have certain, my lord, we have stated what is the distance, my lord. No new construction shall be permitted on private land through and so. The Director General Police Assam and the concerned Superintendent of Police and shall ensure that no illegal mining takes place. In the aforesaid area, no transportation of the illegal mining mineral take place from Karbi Anglong Hill District. According, my lord, at that time in 2019, we have closed the mining of 38, my lord, and the petitioner's mining, my lord, they have shifted to the another place, my lord, at that time. Now, my lord, after furnishing the KML file by the director of Kaziranga National Park, my lord, it is found that the stone quarry of the petitioner from the nearest boundary, we have annexed the document with the GPS map, my lord, that it is within the, my lord, petitioner, it is in the 5.5 kilometer from the Kaziranga Tiger Reserve and, my lord, for Kaziranga National Park and Tiger Reserve.
Where is
It is in
that?
the Annexer 3 PS 59.
Real.
Aerial, my lord. This is the, my lord, big. So, my lord, relying on the file furnished to us by my lord, director of Kaziranga National Park, my lord, showing that the boundary mark and proposed eco-sensitive zone, my lord, we have issued, my lord, passed that, my lord, order, my lord, suspending the operation, giving an operation that we have not yet terminated the mining, my lord. That is the boundary, my lord, that has been, that 5.5 kilometer in respect of, my lord, Kadam Terang P, and in respect of Bronson Terang, my lord, 5.8 kilometer, 81 kilometer, my lord.
That is the other writ petition.
My lord, in other repetition. And in the other repetition, my lord, we have annexed certain other documents also, my lord, regarding, my lord, my lord, direction issued by the Central Empowered Committee. By the Central Empowered Committee issued a notice, my lord. So application was filed regarding complaint regarding the mining in the Parku Pahar range where the petitioner's mining is there, contract is there. Then the Central Empowered Committee issued a direction to the Special Chief Secretary to the Government of Assam Forest Department, my lord. Accordingly, my lord, that we have annexed the, my lord, that is the, my lord, minutes also, my lord.
Where is that? In the other writ petition.
In the other repetition, my lord. Page 50, my lord. Page 50, my lord, Annex 1. Minutes of the meeting held on 27/12/2024.
Page
Page 50, my lord.
50. Oh.
Minutes of the meeting held on 27/12/2024 at 11 on application number so-and-so of the Central Empowered Committee, New Delhi, in the office number of the Special Chief Secretary to the Government of Assam, Environment and Forest Department, Dispur. Member so-and-so. At the outset, the Special Chief Secretary to the Government of Assam, Environment and Forest Department welcome all the members so-and-so. The matter on the application number so-and-so of the Central Empowered Committee regarding the alleged mining activities carried out in the Parku Pahar range under Karbi Anglong Autonomous Council vis-a-vis the order passed by the Honorable Supreme Court in India relating to the ban on mining activities around Kaziranga National Park by the order dated 12/4/2019, which I have already referred, my lord, was discussed at length by the members present. The direction was issued, my lord. The Divisional Forest Officer, Karbi Anglong East Division, will issue a ban on all mining activities at Dolamara Range, Parku Pahar area, from south of Bagori to Borjuri waterfall areas with immediate effect. So it is also the, my lord, though the, my lord, is a transfer subject, but the Special Chief Secretary also on the basis of the, my lord, application issued a, my lord, direction. As my submission is that as the, it is an entrusted subject, so it can be also treated as an advisory to us, my lord. So after taking into consideration of these minutes, the Autonomous Council has also taken the decision, my lord.
Where's the decision?
My lord, I'll submit to my original record. Then, my lord, Annexer 2, page 51 is there.
Yes.
That is the direction, my lord, by the Government of Assam, my lord, to the Additional Principal Chief Conservator of Forest Come CSD, application number so-and-so received from the Central Empowered Committee. It has been observed that the order of the state government for closure of some stone mining quarries in Parku Pahar area in a CSC report matter has not been followed even after a month, after more than 2 weeks. You are directed to follow the order of the state government 4 weeks. So there is a direction from the state government also regarding the mining on the basis of the CEC, my lord.
Okay.
And my lord, State Expert Appraisal Committee also. And we have that district survey report we have submitted to the my lord, that particular committee, that who is authority, my lord, for issuance of the my lord environment clearance, my lord. We have submitted it. They have also passed the my lord order for closure of the mining, my lord. That is, my lord, Annexer 3, page 55. That is the particular mining, my lord. Page 55, my lord. That is the observation, my lord. My lord, State Expert Appraisal Committee, my lord. SEAC, my lord, Assam. My lord, remark column, not permissible without the approval of the National Board for Wildlife. And NOC from the competent authority, Assam, due to eco-sensitive zone of Kaziranga National Park and Tiger Reserve as falling within 10-kilometer radius. So whole case, my lord, relates to the whether the mining, if it is in the proposed eco-sensitive zone, then as per the order of the Supreme Court also, there cannot be any mining. And if we are following the order of the Supreme Court, so for suspension, we are issuing the suspension, no notice is required. For cancellation, 60 days notice is required. And my lord, Central Empowered Committee issued a direction to us also, my lord, to appear before us regarding the mining activities in that particular area, which we have annexed as Annexer 3, page 71. In the other case, my lord.
In the other case, means
In this case, particular case, Bronson Terong case. Page 71.
71.
Page 71.
How many affidavits did you
We have
have?
filed 2 affidavits, my lord, in that case. My lord, one is by the additional principal chief conservator of forest, and this is by the my lord divisional forest officer.
Okay.
2 authorities are there.
Page 71.
Page 71, affidavit of divisional forest officer, my lord. My Central Empowered Committee, my lord, notice that letter dated 20th March 2025. Submission of report. It is addressed to the Special Chief Secretary, Environment Forest Department, Government of Assam. Submission of report regarding complaint on mining activities in the Parku Pahar Range, a wildlife sanctuary in the southern boundary of Kaziranga National Park. Sir, I am directed to refer to the letter dated to ensure of the PCCP and Head of Forest Assam regarding the submission of the factual report on the subject cited above. The submission made by the Assistant Assam Forest Department have been taken into consideration. The CEC has been informed that a draft eco-sensitive zone notification of Kaziranga National Park has been issued by the state government of Assam. The Honorable Supreme Court of India, in its order dated 036/2022 in repetition number so and so, has inter alia directed as follows. That is, my lord, I have referred in the judgment, it is 56.2. Here they have put it as 44.3, my lord. The same judgment, my lord. In the event, however, the eco-sensitive zone is already prescribed as per law that goes beyond 1 kilometer buffer zone, the wider margin and eco-sensitive zone shall prevail. If such wider buffer zone beyond 1 kilometer is proposed under any statutory instrument for a particular national park or wildlife sanctuary, awaiting final decision in that regard, then till such final decision is taken, the eco-sensitive zone covering the area beyond 1 kilometer as proposed shall be maintained. So that is the direction, my lord, and the CEC also taking into matter and issued a direction to us, my lord, that is in the paragraph, last paragraph. That paragraph 3 also, as the same mine lease falls under draft eco-sensitive zone, the mining leases should have been ideally cancelled rather than just has been suspended.
Where is that?
Page 72.
Hmm.
Though the CEC observed that as the said mine leases falls under the draft eco-sensitive zone, the mining leases should have been ideally cancelled.
Where are you reading from?
Page 72, my lord.
I'm on 72. Para?
Paragraph 3, first paragraph. There are 2 paragraphs, 3 like that. First paragraph.
Uh-huh.
Moreover, as the said mine lease falls under draft eco-sensitive zone, the mining leases should have been ideally cancelled rather than just being suspended. You are also directed to ensure that no fresh mining leases are granted in these areas in compliance with the orders of the Honorable Supreme Court of India as referred to above. So, though they have asked us to cancel it, but for cancellation, 60 days notice is required. We have only issued a suspension. Next paragraph, my lord. In this regard, a meeting is being convened at CEC on 4/4/2025, my lord, tomorrow. and you are hereby directed to remain present along with the authorized representative of Karbi Anglong Autonomous Council and other related officers. You are expected to submit a detailed and comprehensive report during the meeting explaining the circumstances under which the violation of the Supreme Court's order has been occurred. So, my lord, CAC also has taken into, my lord, account all those aspects. And as per direction of the Honorable Supreme Court also, she is the authority, my lord. So the petitioner can also approach the CAC, ventilating their grievances, my lord. My lord, the meeting has already been on 4/4/2025, but my instruction is today that that has been postponed to on 10:30 AM of 7, Monday, my lord. The meeting will be held on 7, my lord, where Karbi Anglong Autonomous Council representative of the KSU also is required to be asked to be present on CEC, my lord. So, my lord, at this moment, my lord, so my submission is that, my lord, if the petitioner may, my lord, approach the CEC as per the direction, as the for cancellation, no notice has yet been issued, my lord. Only regarding the issue of suspension, they can submit an application for review. We are also taking into account the draft eco-sensitive notification. We also wrote to the government, my lord. My lord, we can consider it, but reconsider it also. That is my submission.
May I please, your lordship? My lord, I am a little confused. I am making an honest confession. First, they say that we should file an application before the council because they have the authority. Second, they say go to CEC. And thirdly, they say under the rules we are competent in view of the amended 6th schedule. So move an application before the council. Now they have to make up their mind. We can't do three things together. But let us, Milord, this is a very, in my humble submission, Milord, let us look at the facts. Your lordships have seen the facts. Earlier, at one point of time, one area was given to us. Pursuant to Supreme Court's order, shifting has taken place. We have not chosen the area. They have given us the area. That is page 21. DFO himself is passing that order, saying that it is beyond 10 kilometers of the border of Kaziranga. We have started. We are continuing. The admitted fact is that our mining plan has gone through the processes contemplated under the law. I have placed all those stages. The environmental authority has cleared. The other authorities required to see, they have seen, they have cleared. After that, Milord, we were allowed to operate there. And without any problem, we have been operating until this impugn order comes. Without any notice, without any opportunity. So the admitted facts are that they have approved the mining plan and conferred the right to operate in accordance with law. And they have said that this area is beyond 10 kilometers of the boundary. That's on record. And we are operating. Now you pass the impugn order. And it is an admitted fact now that no notice was given, no opportunity was given before terminating, suspending the operations. That is admittedly again opposed to the Rule 6, which details the procedure for suspension. So, question involved in this case is, can you after conferring the right to operate, unilaterally, without notice, without any opportunity being given, suspend the right to operate. That's the only issue. Admitted fact is they have not given any opportunity. There is no denial. Forget the CEC, forget the council, nobody has given. Who has given an opportunity? No. They have accepted that fact. And now they say, come to the council, we'll review. We will review the entire thing. I can understand if they had taken genuinely this, I will welcome it. But the admitted fact is that you have suspended in violation of the rule. Rule requires you to give notice and the grounds why you are suspending. That's rule 6. A detailed procedure is given. So even in the agreement, Milord, for a moment, let us assume that the DFO is the competent authority. I am not conceding, I am only assuming because they are saying that DFO, very well, he is the competent authority, he was authorized, let me assume. Has he done what the statute requires? Has he given us a notice? No. That is absolutely an admitted fact in this case. On admission, and it is not a very straight and simple case. You confer a right, which is admitted. We operate on the basis of that right. That is admitted. We have not violated, there is no allegation of any violation by us. That is admitted. It is also admitted that they have not issued the notice required under the law. Apart from the principles of natural justice, here a statutory rule requires them to do. Now, what can the court do?
What about that rule 3811 that the standing council was saying that they have invoked rule 3811?
There also notice is required. Kindly have a look at that rule, rule 38, at page 298, I think, no? Page given, rule 271. See the rule number. Rule 38 starts at page 268. General conditions for grant of any mineral concessions. And they are relying on rule clause 11, 3811 at page 271. Let us see the rule also. Where the continuance of mining operations in any area, in the opinion of the state government, is likely to endanger the safety of any national or state highway, road, bridge, drainage, reservoir, tank, canal, or other public works, or public or private building, or any other public interest, or in the interest of environment, ecology of the area, the government may suspend the operations in the entire concession area or part thereof with immediate effect by communicating the reasons thereof in writing. The government may, wherever so warranted, terminate such mining lease contract over entire area or part thereof after giving 60 days notice to the concession holder in this behalf, and the grant of such mineral concession shall stand terminated from the date specified in the said notice. Now, my lord, has the government done anything in the matter? This is a power vested. I have, in my opening, I have indicated the different provisions. My lord, in some, the director, in some, the rights of the state government. So this whole thing is the right of the state government, my lord. If your lordship see the beginning of that rule, general conditions for grant of any mineral concessions. And then, my lord, this is a power under subclause 11, my lord, of the state government. Has the state government passed an order here? The answer is no. That's why I was, my lord, trying to submit with great respect, my lord, to all the decisions we have troubled your lordship with, and theirs also. It is, my lord, a very simple affair. They have allotted a particular area. The authorities competent to consider the mineral plans have considered. They have given the right. We are operating. All these, my lord, will require that these are hedged with conditions, clause 11. Because of several reasons given, the state government may take an opinion or form an opinion after notice that this should be suspended. Entire area should be taken off. That is not the case here. State government has not done anything. We are concerned with the impugned order is by the DFO. Assume he is a competent authority. Can he do what he has done? And 27, 12, 24, they are relying. That gives a direction to the DFO to terminate. He is not exercising any independent mind. Your lordships remember that case? Can anybody dictate to the statutory authority do this or do that? Assuming that DFO is competent, which we don't concede. Therefore, what is the case here? We are not concerned with the environment or the eco-sensitive zone. We are given by them to operate. We are operating. You want to close, very well. Follow the law and close it. If you don't do it, the order is void. And, my lord, I can't understand. I am before the High Court. It's a constitutional court conferred by Constitution the powers to issue all the writs. And you are asking us to go to the CEC with this petition pending and heard by your lordships? What kind of a suggestion is this? Has the High Court been taken away with its powers for the environmental matters? No. Who can take away that power conferred under the Constitution? And your lordships have held, Supreme Court has held, that if there is a violation of natural justice, alternative remedy is not an answer. Two exceptions, my lord. One, if you don't have the jurisdiction, alternative remedy is not relevant. If you have violated the principles of natural justice, it's null and void. That is no issue. That is, my lord, your lordships remember that case, AR 69, Supreme Court 556. Two exceptions. Worldful makes it three. So ultimately, my lord, it's a simple case. I am conferred a right. You are now suspending it without notice. Suppose there was nothing in the statute, even then it would have been bad under the general principles of natural justice. But here we are in a better position because the rules require that you have to give notice. Therefore, my lord, I have no problem. If they want to review the matter, welcome. Keep it. Keep this matter pending. Allow them. We'll move an application if they want. But within 2 weeks, let them inform the court as to what they have decided. And they are talking of proposal before the High Court or before the Union government. Proposals given. They are not producing before your lordships. Why? Why are they not producing that document before your lordship? What is the distance they have said?
Yes, that is one thing.
Absolutely, my lord. Let them say it. Your lordship will see what the position is. Why an undisclosed anonymous complaint, the sea is taking so much importance. Don't think that we don't know what is going on. Who is where? And anonymous complaint comes. CEC just see the documents they have placed before lordship. He passes an order directing the state government with great speed in all their movements. Nobody is, we can't disclose, I can't disclose more than what I know. But that apart, why are they not bringing that proposal before lordship? Have they specified a distance somewhat which is within this? No. We know, we have seen it. A journalist filed an RTI. The reply by the director is that there is no within the zone of 10 kilometers, there is none. Proposed eco-sensitive zone may specify something beyond 1 kilometer. That is the law. You have proposed, it is pending before the Union government. What have you proposed for this area? They have given different distances for different areas. And this area, which belongs to that southern part of Kaziranga, they have given a distance. They are not disclosing it before your lordship. That's not fair to the court. If you are raising a non-issue for the purpose of this case, be fair and disclose everything. If you want to come under the cover of an environmental issue, have that fairness to produce before the court what you have proposed in the proposal. They can't. That's why that document is shut out from your lordship with all these 300 pages of annexures. That's the whole trouble. Therefore, we are not concerned with the environmental question because the authorities which have given the power, they are supposed to look at this environmental angle. They have. Their clearances are given absolutely clear. Your lordship has seen that document. We have annexed that. I placed every document. So there is no problem with her operation. If you have given even a proposal, I could have understood that it includes. That is not even the case.
Yes,
Let them show that proposal.
who has sent the
My lord,
proposal?
only I'm just referring, my lord, take a note of it. There's a state cabinet decision, my lord, regarding the proposal on 28/3/2022. We have annexed it, my lord. Annexure 4, page 59.
Annexure?
Annexure 4, page 59.
Of which writ petition?
My lord, 1000 and Bronson Terang petition.
Bronson.
Oh.
Okay.
Annexure 4 page, my lord, 59. My lord. That is we are referring that 16/12/2014 24 letter, that was by the field director later, my lord, we have referred. With reference to the subjects later cited above, it is to inform you that the Honorable Cabinet, Government of Assam in its meeting held on 28/3/2022 discussed the proposal for integrated eco-sensitive zone and KNP-TR along with the maps and approved the proposal. Therefore, your mentioning of in the above quoted letter that the KML file of the map of KNP-TR, including proposed eco-sensitive zone boundary of so-and-so is still yet to be finalized is not correct. As the Environment and Forest Department, Government of Assam submitted the proposal to the Ministry as approved and finalized by the Honorable Cabinet Government of Assam. The process for notifying the integrated so-and-so eco-sensitive zone of KNP and Tiger Reserve is going on in Ministry of Eco.
No, that's fine. That's fine.
So, my
But
lord,
the-
it is the state government, my lord. So I am submitting it. The state government sent the proposal to the ministry, my lord. My lord,
So in the proposal,
my lord,
what is the
whether-
buffer
okay,
zone?
my lord. That we are, my lord, asking for the, my lord, by way of letter, my lord. That is the letter, we are sent a letter to the government to submit the proposal to us also, my lord.
What is the government?
My lord, government is there, my lord.
Attack?
I'll just.
My lord, that is our letter, my
No,
lord.
that
My
letter
lord.
that we have seen this
My
letter. This is a letter,
My lord.
but then where's your proposal?
That is
And in the proposal, what is the buffer zone?
Perhaps, your lordship, we may need to examine what is under challenge in this writ petition first. If your lordship has
No.
1009,
The challenge is to the suspension of the
yes,
mining of the petitioners,
lordship,
right?
lordship,
In that order,
lordship,
they've brought in the Supreme Court's
yes,
orders.
lordship.
Now, on the basis of the Supreme Court's order, now this court wants to know what is the buffer zone?
Lordship, though there is a reference to the Supreme Court order in the suspension order, the affidavit filed by the Karbi Anglong Autonomous Council shows that that order was passed pursuant to recommendations by the CEC. So before going into the issue of what is the buffer zone, we'll have to first examine what is the role of the CEC and whether they could have passed such passed such directions at all. Because the lordship will appreciate that the order passed by the CEC is not under challenge. So otherwise the legal principle is settled. That the challenge to a consequential order without challenging the main order, that challenge is not maintainable. So here they have only challenged the letter. They have only challenged a letter issued by the forest officials without challenging the primary direction passed by the CEC. Now we have filed an affidavit. There, I'll just give your lordship a background of what the CEC was. Initially, your lordship, the CEC was the body created by the Supreme Court in the TN Godavarman proceedings, that all matters pertaining to environment, during such proceedings, those materials were to be placed before the CEC. The CEC would examine them, place a report before the bench examining the matter, and on that basis, orders would be passed. Thereafter, your lordship, that CEC was notified under Section 3 of the Environment Protection Act. Then that situation continued. Recently, your lordship, pursuant to directions passed by the Apex Court, the CEC was made a permanent body with a permanent secretary, permanent members. Their powers are delineated, the procedure to be adopted, what is to be done. And taking cognizance of that, the Honorable Supreme Court has said that when a CEC makes a direction, there are two options with the state government. They can either comply with the direction or they can say that we don't comply. If we do not comply, then we have to submit a report to the CEC why we do not comply. And for that Supreme Court judgment as well as the notification permanently notifying the CEC says that any person who is aggrieved by any decision passed by the CEC has an option of challenging that decision before the CEC, to which an appeal will lie before the Supreme Court. So I'll just quickly point those position judgments before your lordship, place those notifications. Then your lordship may examine, because the learned senior counsel has correctly said, those are not materials which are there in the affidavit, because the affidavit primarily your lordship is only concerned with the position of the CEC and what the position of the CEC currently is. If I may just quickly take your lordship to those judgments. So lordship is aware of the previous position. The judgments have already, those judgments perhaps the learned senior counsel has already taken your lordship through. In the Goa Foundation case, what has happened, the buffer zone of the ESZ of 10 kilometers, which is to be maintained till the final notification is issued. So I will not go into those issues, your lordship. If I may take your lordship to annexure F at page number 326, your lordship, of the affidavit in opposition.
You're the standing on the forest.
This is an affidavit filed on behalf of the respondent numbers 4 and 5, the Forest Department, Government of Assam.
Yes, page.
Page starts at 326, your lordship.
Yes.
320, if your lordship has 326, the English portion starts at 327. This is a notification of 5th of September 2023. I just read out the notification, your lordship. It makes a lot of things very clear, your lordship.
Yes.
But I don't want to interfere, but I must point out that these issues are not arising for your lordship's consideration in this case. CEC has not come into the operation. I am challenging an order by the DFO. Assume he is the competent authority. Can he suspend the way he has done? That's this short question. And they have never denied that no notice was given, no hearing was given. It's an open and shut case. We don't have to go into all this.
I'll establish why this is necessary, your lordship.
Okay.
Question must arise before all this is done.
If I may read page number, start from page number 327. In exercise of the powers conferred by subsection 3 of section 3 of the Environment Protection Act 1986, and in supersession of earlier notification dated 17 September 2002, the central government hereby constitutes a permanent authority to be known as the Central Empowered Committee, hereinafter referred to as the committee, consisting of the following members, appointed in pursuant of the Honorable Supreme Court's order dated 18th August 2023 in IA number 196062 and 174896/2019 in WPC number 202 of 1995 for the purpose of monitoring and ensuring compliance of the orders of the Honorable Supreme Court covering the subject matter of environment, forest and wildlife and related issues arising out of the said orders, and to suggest measures and recommendations generally to the state as well as the central government for more effective implementation of the Act and other orders of the court. A. Chairman, having special knowledge and experience of 25 years in the field of environmental, forest and wildlife, or a person with a proven administrative efficiency of not less than 25 years in the central government and or state government, shall be nominated by the central government for a period of 3 years, which can
This we can skip. This
Yes, very well. Then the powers and functions and the qualifications of the chairman, member secretary, and 3 expert members are given. Number 2, your lordship. The committee shall exercise the following powers and functions and perform the following functions. This will bear some relevance. Powers and functions conferred upon the committee by the Honorable Supreme Court of India in WPC number 202 of 1995 and 171 of 1996 in the case of T.N. Godavarman Tirumalpat versus Union of India and others, to monitor the implementation of the Supreme Court's orders in the above matters and place reports of non-compliance before the central government for appropriate actions, to deal with any applications made to it by any aggrieved person, and wherever necessary to make a report to the central government in that matter. For the purposes of effective discharge of powers conferred upon the committee under this order, the committee can call for any documents from any person or the government of the union or state or any other official, undertake site inspection, seek existence or presence of any person or officials required by it in relation to its work, Co-opt one or more persons as special invitees for dealing with specific issues. Co-opt wherever feasible the secretary of the state government dealing with the subjects related to forest or wildlife or environment, or his representatives or the principal chief conservator of forests or the state as special invitees while dealing with issues to a particular state, to suggest or recommend measures generally to the state as well as central government for the more effective implementation of the Act and other orders of the Supreme Court in the above matters, to examine and advise or recommend any issue referred to the committee by the central government from time to time. So I'll quickly draw your lordship's attention once again to clause 2B, 2A, small b, which says that the committee can deal with applications made to it by any aggrieved person and wherever necessary make a report to the central government in that matter. Now, your lordship will see this notification as the Supreme Court has taken cognizance of this notification. And that order passed in the proceedings, your lordship will find at 329 of this article. Lordship, this order judgment is divided in two parts. The first part bears relevance to these proceedings. I'll just read the first part here. This judgment is in context of the institutionalization and reconstitution of the Central Empowered Committee. The CEC was originally directed to be constituted by an order of this court dated 9/5/2002. Almost for a period of 2 decades, the CEC was functioning as an ad hoc body. We noticed that the present composition of the CEC also consisted of persons who are more than 75 years of age, and some of whom are also residing outside India. We also noticed that much water has flown when the CEC was initially constituted, inasmuch as various enactments concerning environmental issues were enacted and also various regulatory bodies were constituted under the said enactments. We further found it necessary to have a relook at the CEC's functioning. We therefore pass orders dated 24/3/2023 and 18/5/2023 in this regard. This order also bears mention in the notification. The Ministry of Environment, Forest and Climate Change thereafter issued a notification dated 5/9/2023 under Section 3(3) of the Environment Protection Act 1986, constituting the CEC as a permanent body for the purpose of monitoring and ensuring compliance of the orders of the Supreme Court, covering the subject matter of environment, forest and wildlife and related issues arising out of the said orders, and to suggest measures and recommendations generally to the state as well as the central government for more effective implementation of the Act and other orders of the court. By our order dated 18/8/2023, we have approved the said notification. While approving the notification, we also declared that the CEC shall continue to function subject to orders and directions that this court may pass from time to time. This is important. In part 1 of this judgment, we'll first present the conception, constitution, functions, and finally the institutionalization of the CEC. In part 2, to entrench environmental rule of law in our environmental governance, we have attempted to formulate some new principles for the effective monitoring of various bodies, institutions, and regulators established for protecting our forests, wildlife, environment, and ecology. Part 1. The original constitution of the functioning of the CEC till 2023. This court endeavors to protect forests in India and to ensure regulation of non-forest activities in forests commenced in 1996. Even prior to the constitution of the CEC, this court directed the constitution of various bodies to oversee and monitor the compliance of its orders. In one of the most important orders dated 12/12/1996, this court defined the term forest as covering all statutorily recognized forests, irrespective of how they were designated, either as reserve forest or otherwise. The term forest land in Section 2 of the Forest Conservation Act 1980 was held to include any area recorded as a forest in government records, irrespective of its ownership, along with mandating prior approval of the central government to undertake any non-forest activities in forests and issuing directions on the felling of trees. This court also directed the constitution of expert committees by each state government to identify forests and sustainable existence of sawmills in forests. This court also directed each state government to constitute a committee with the PCCF and any other senior official to oversee the compliance of its orders and the filing of status reports by the states. In its order dated 4/3/1997, this court constituted a high-powered committee to oversee the implementation of its orders in the northeastern region and to also oversee preparation of inventory of timber apart from permitting its sale. By order dated 17/4/2000, this court empowered the HPC to also supervise the transportation of illegal timber, oversee investigation into cases of illegal felling of trees, and to re-examine licensing of units. The CEC was constituted by this court by order dated 9/5/2002 to monitor the implementation of its orders and to present cases of non-compliance, including with respect to encroachment removals, implementation of working plans, compensatory afforestation, plantations, and other conservation issues. This court directed that the CEC must be constituted until such time that the central government constitutes a statutory body under Section 3 of the Environment Protection Act. The CEC so constituted comprised of a chairman nominated by the Minister of Environment and Forest in consultation with the amicus curiae, a nominee of the MOEF, 2 NGOs were to be nominated in consultation with the amicus curiae, and a member secretary. These members could not be removed without the court's permission. The above order required that the reports and affidavit filed by the states pursuant to this court's orders were to be placed before the CEC for its examination and recommendations. The recommendations of the CEC would be placed before this court for orders. Further persons who are aggrieved by any steps, Lordship may kindly take a note of this, taken by the government in purported compliance of this court's orders would seek relief from the CEC, which must decide the applications in conformity with the court's orders. To perform these functions, the CEC was given the power to call for documents from any person or government, summon any person and receive evidence on oath, and seek assistance presence of any person or official, including the power to co-opt persons as special invitees for dealing with specific issues. When an issue pertains to a particular state, the Chief Secretary and the PCCF of that state were to be co-opted as special invitees where feasible. The composition of the CEC was finalized by this court by an order dated 9/9/2002. In this order, the court also took note of the draft proposed notification under section 3 subsection 3 of the Environment Protection Act that constituted the CEC as a statutory body for 5 years. The court directed that once the notification is issued, the functions and responsibilities of the CEC are to be exercised as a statutory committee. The central government issued a notification constituting the CEC under section 3 on 17/9/2003. Now, Your Lordship, why I have taken Your Lordship to this is because these powers, which the CEC was exercising prior to issuance of the notification itself says that the CEC will continue to exercise those, including examination of any grievances which any person may have to any orders passed by the CEC. Then, Your Lordship, the first modification of the order dated 9/5/2002 came by way of order dated 14/12/2007. The modified order reference which superseded all previous orders were as follows. I will not take Your Lordship to this. This is, we can refer to in the succeeding paragraphs. Paragraph number 9. The composition of the CEC was modified by this court by its order dated 21/2/2008, and the term of office of the new member was directed to be for 3 years or until further orders, whichever is earlier. In another order dated 11/9/2009, one of the members of the CEC was replaced, and by order dated 3/3/2017, the member secretary was replaced. Now, para 10 onwards, Your Lordship, it bears relevance because it describes the CEC as it stands now, Your Lordship. What are the powers that it is clothed with, what it can do, and whether if any party has any grievance regarding a decision taken by the CEC, what is the mode of redressal of that grievance? Should I continue, Your Lordship?
Fine.
Very well. Challenge, because it is at the end of the day communication issued by the DFO that has been issued to comply with a direction passed by the CEC. By the CEC.
We are not told that.
So, because the affidavit that has been filed, the sequence of events will reveal that that has been done because the CEC had said that mining activities in Parku Pahar should stop. So, if that be the case, and then there is an order which is now on record existing of a direction passed by the CEC, this judgment will reveal that what is the mode of redressal of any grievance against such an order. That is my reason for taking Your Lordship to that order. Can I may continue from page number 336, Your Lordship?
Yeah.
Yes. So, paragraph 10 and 11, Your Lordship, what had happened was the Honorable Supreme Court, while deciding another interim application, was of the view that the CEC, which was the body that it had constituted, now was in effect sitting over judgments that the Supreme Court had, orders that the Supreme Court had passed. So, that was held to be improper, and so permanent body was sought to be constructed. So, I'll read from page number 337 onwards, Your Lordship. there an order of 24/3/2023 is extracted. I'll read from that. Para 10. In any case, we are of the view that once an order is passed by this court, it is not appropriate for a committee which was constituted under the very orders of this court to give a report which is in effect questions the correctness or otherwise of the order passed by this court. A committee which is constituted under the orders of the court cannot consider itself to be an appellate authority in regard to the orders passed by this court. We are further informed by the learned Solicitor General that at times the members of the CEC are not ad idem on all the issues which are ultimately reported to this court. We therefore direct that hereinafter, whenever there is a separate or dissenting opinion on any of the members of the CEC, such opinion shall be placed before this court along with the report. It is further informed that some of the members of the committee have crossed the age of 75 years and some of the members are also living abroad. No doubt the committee has rendered human services to the cause of the environment. However, we are of the view that for effective functioning of the CEC, it is appropriate that some experts in the relevant fields who are relatively younger to the present incumbents can contribute in a more energetic and efficient manner. It will therefore be appropriate that some of the old members who have attained an advanced stage or are not available in India all the time are replaced by younger members. We therefore request the learned Solicitor General and both the learned amicus curiae to give a list of persons who have expertise in environmental and ecological fields. The same shall be done within 3 weeks from today. List the application in so and so. When the matter was next listed on 18/5/2023, the learned Solicitor General submitted that the central government had accepted the suggestion of this court to constitute the CEC as a permanent statutory body. The Union of India was to publish a draft notification under Section 3 of the Environment Protection Act to constitute the CEC within 15 days and place the notification before this court. This notification would contain provisions of the qualification of members, their tenure, powers and responsibilities, etc. The relevant portion of the order dated 18/5/2023 is extracted below. On the last date when the matter was heard, a suggestion was made by the bench that instead of the CEC being an ad hoc body, it would be in the larger interest that the CEC as an institution should be a permanent statutory body. The learned Solicitor General has accepted the said suggestion. He states that the Union of India would publish a draft notification under provisions of Section 3 of the Environment Protection Act, providing for the constitution of the CEC. He submitted a draft notification which contained provisions related to the qualification of the members to be appointed, their tenure, their powers, responsibilities, etc. Learned Solicitor General submits that the draft notification will be published within a period of 15 days from today, and that the same shall be placed before the court on the next day. On 18/8/2023, a draft notification was issued by the Ministry of Environment, Forest and Climate Change for constitution of the CEC, was placed before the court with a copy of the learned amicus curiae. We examined the draft notification in detail and made certain suggestions about incorporating certain features of the effective and efficient functioning of the CEC. Certain suggestions were also made by the learned amicus curiae. The learned Solicitor General did not have any objection to the same and submitted the suggestions would be incorporated in the final notification. Pursuantly, the central government was permitted to proceed with the issuance of the notification to constitute the CEC as a permanent body in the interest of all stakeholders. This court also permitted the MOEF to proceed with the constitution of members of the CEC in accordance with the notification. The relevant portion of the order passed by this court is extracted below. This I will not take your trouble, your lordship with. Paragraph number 14 again. Pursuant to the above orders dated 18/5/2023 and 18/8/2020. Here we come to the notification, your lordship, which I had taken your lordship through. The MOEF issued a notification dated 5/9/2023 under Section 3, subsection 3 of the Environment Protection Act to constitute a permanent authority, that is the Central Empowered Committee, for monitoring and ensuring compliance of this court's orders, covering the subject matter of environment, forest and wildlife, and related issues arising out of these orders, and to suggest measures and make recommendations to the states and central government for more effective implementation of the Act and the court's orders. This I need not trouble your lordship through. Lordship has already gone through that. It will consist of a chairman, members, member secretary. I'll take your lordship to paragraph number 17, because that bears some relevance to the present issues. This notification provides that the states or the central government shall give reasons in writing for not accepting any suggestion or recommendation of the CEC, and the decision of the central government shall be final. Further, in case of deferment of the decision of any state government with the CEC's recommendation, the matter shall be referred to the central government, and decision of the central government shall be final and binding. We may clarify at this very stage that the decisions of the central government and or for that matter the state government are always subject to the orders of this court. The Supreme Court has said that the state government's decision to follow or not follow, that can always be subject to directions passed by this court because the committee, after all, reports directly to the Supreme Court. When this notification was placed before us, we clarified this position and we hereby reiterate that the order of the state and our central government under clause 3 and 4 will be subject to any direction or order that this court may pass from time to time. Paragraph number 21 for once, Your Lordship. Some further directions were passed. We further direct the CEC to adopt the following measures to promote institutional transparency, efficiency, and accountability in its functioning. The CEC shall formulate guidelines for the conduct of its functions and internal meetings. The CEC shall formulate the operating procedures delineating the roles of its members and the secretary of the CEC. The CEC shall formulate guidelines about the public meetings that it holds, ensure that the publication of meetings agenda in advance on its website, maintain minutes of meetings and set out rules regarding notice to parties. The CEC shall formulate guidelines for site visits and, if necessary, hearing the public and affected parties therein. The CEC shall formulate guidelines fixing times for site visits, preparation of reports, and also the manner of preparation of reports. We further direct that these guidelines or regulations must be accessible for anyone to seek. They shall be posted on the official website of the CEC. The rest, the other part does not bear relevance to the issue in hand. Now, if I may take your lordship to the affidavit that has been filed on behalf of the council by the additional PCCF of the council. And if I may turn your lordship, take your lordship to page number 50.
50?
50. Lordship has page number 50. Yes. This is a minutes of the meeting on 27/12/2024. That is after constitution of the CEC and after the judgment of the Supreme Court in Delhi. Now, if I may take your lordship to what was decided. At the outset, the Special Chief Secretary to the Government of Assam Environment and Forest Department welcomes all members to the meeting. The matter on the application number 1592/2024 of the CEC New Delhi regarding the alleged mining activities carried out in the Parkuk Pahar range under Karbi Anglong Autonomous Council vis-a-vis the orders passed by the Honorable Supreme Court of India relating to ban on mining activities around Kaziranga National Park by the order dated 12/4/2019 was discussed at length by the members present. After a threadbare discussion, the following decisions have been taken as elucidated below. The DFO Karbi Anglong will issue a ban. Lordship will see the officer who has been entrusted. Will issue a ban on all mining activities in Dolmara, Parkuk Pahar area, which is the present area in concern, from South Bagori to Borjuri waterfall areas with immediate effect. The DFO Karbi Anglong East Division will submit a comprehensive report on the alleged mining activities presently undertaken in the above areas within pre-1/2024. It was also decided that the PCCF and HOF, the additional PCCF so-and-so at Karbi Anglong, and the Chief Conservator of Forest, Office of the PCCF and Head of Forest Force will undertake a field inquiry into the matter and furnish its report to the Government of Assam through the Office of the PCCF within a week's time. The meeting ended with thanks. Pursuant to this meeting on 27/12, Lordship will see that the PCCF has written to the additional PCCF. PCCF Assam has written to the additional PCCF Karbi Anglong, which is on the next page, at page number 51. It has been observed that the order of the state government for closure of some mining quarries in Parkuk Pahar area in a CEC referred matter has not been followed even after more than 2 weeks. You are directed to follow the order of the state government forthwith. Now, it is in these circumstances that the impugn communication came to be issued, Your Lordship. Because the attending facts and circumstances have to be seen. Now, let us test their argument. For once, let us say there is some mistake in the order passed by the CEC. That it appears to be so because the order which is referred to in the minutes of the meeting of the CEC refers to a proceeding which was primarily concerned with stopping illegal mining in the areas in and around Karbi Anglong, but including the catchment areas of the rivers flowing into Kaziranga from the Karbi Anglong hill ranges. So that IA has been closed. Your Lordship has already gone through that order. There an affidavit was filed by the state saying that we have stopped all mining activities. So taking that affidavit into account, the Supreme Court closed those proceedings. Now, the CEC has taken a note of that order and has passed subsequent directions, saying that it is seen that there are still mining activities going on in these areas. The DFO has been directed to forthwith stop them. And the government of Assam, since it is entrusted under the notification to comply with the directions passed by the CEC, it has passed directions to the authorities in Kambi Anglong to comply with those directions. Now, if they are aggrieved by this direction passed by the CEC, they may have some genuine grievance. Since it involves complicated environmental issues, they should file an application before the CEC, which has expert members to deal with such issues. And if at all they are aggrieved by some orders passed by the state government. At paragraph 17 of the judgment, which I had just taken your lordship through, the Supreme Court has said that such orders will be subject to further orders that may be passed by the Supreme Court. Now, just one thing I wanted to bring to your lordship attention, of course, that is not binding. Prior to notification of the permanent CEC as it stands now, some earlier applications were also filed before this honorable court. In one of the applications, a stone crushing unit in Karbi Anglong, which was then directed to stop mining because of the dependency of the IA related to stone crushing, they filed an application writ petition before this court. They said that the IA is only concerned with mining, not with stone crushing activities. And they said that since it doesn't concern stone crushing activities, how can you stop stone crushing? So lordship will kindly have a look at the order that this honorable court was pleased to pass, which your lordship will have at page number 389, your lordship. So I will take your lordship to the relevant portion immediately, which starts at page number 391. The facts are that a notice was issued to stop them from operating stone crushing unit. They said that since their IA only deals with stopping illegal mining, stone crusher units are not covered. So lordship will kindly see what a coordinate bench of this honorable court held, your lordship. At paragraph number 5, at the bottom of the page, this court, upon hearing the learned counsels for the parties, is of the opinion that the words used in the order of the Supreme Court dated 12/4/2019 mentions about mining and related activities. It is also seen that the proceedings are presently pending before the Honorable Supreme Court. And in the opinion of the court, it would not be proper for giving an interpretation to a term used in the order, that too when the said proceedings are presently pending before the Honorable Supreme Court. Under such circumstances, this court, while not interfering with the order dated 30/4/2019, as has been assailed in the instant proceedings, observe that the petitioner would always be at liberty to approach the Supreme Court to seek clarification as to whether the stone crushing unit would come within the ambit of the word related activities as mentioned in the order dated 12/4/2019. Taking into account the order, the rest is that he was permitted to lift the materials. But basically, regarding his primary dispute, your lordship, the honorable court refused to interfere, saying that the proceedings are still pending. Now, lordship is aware that proceedings in TN Godavarman, those are continuing proceedings. Some IAs may be closed, but the proceedings themselves are still continuing even till today, your lordship. And in the same proceedings, this order was also passed, the last order which I had taken, your lordship. Again, your lordship, another PIL happened to be filed before this division, before this court, saying that the directions pertaining to notification of eco-sensitive zone in Karbi Anglong, in Kaziranga, that was not being followed. Now, lordship will see, even in those cases, the division bench of this honorable court was pleased to adjourn such proceedings sine die, because these issues are pending before the honorable apex court. Lordship may have the order which starts at page number 395.
That we have seen.
Yes, the relevant portion is at 396. So because otherwise this regulation of mining activities is a transferred subject. But my limited prayer, since I am been arrayed as a party, the Policy Department, Government of Assam has been arrayed as a party in these proceedings, is that the government is now required to follow the directions of the CEC or otherwise give decisions for not following. And we have no reason not to follow them. We have passed an order. They say that they are not happy with that order, the consequence of that order. But Lordship will see that they have not challenged that order of the CEC. What they have challenged is a communication which has been issued pursuant to such order. Lordship, the proposition of law is that you cannot challenge a consequential order. The primary order has to be challenged. So I'm just relying on one judgment. So the facts are different. The legal proposition has been reiterated. This is 2010 1 SEC 756.
2010.
7 SEC 1 7 2010 1 SEC 756. 1 SEC 756. I'm just relying on the legal proposition laid down at paragraph number 22. It is a settled legal proposition that challenge to a consequential order without challenging the basic order stroke statutory provision on the basis of which the order has been passed cannot be entertained. Therefore, it is a legal obligation on the part of the party to challenge the basic order, and only if the same is found to be wrong, consequential order may be examined. So the CEC order, which is at page number 50 of the affidavit, that is the foundation of everything which has happened subsequently. But that has been remained untouched. So if at all there is any grievance regarding the order or the procedure adopted to comply with the order, because the order says immediately, they have an alternative remedy. And if they are aggrieved by the order of the CEC or the state government, the Supreme Court has said that such decisions or the order of the state government will be subject to further direction of the Supreme Court. And that has been consistently followed by coordinate benches of this court also. So that is my limited submission on this point, Your Lordship. Our affidavit is limited to these issues only, Your Lordship. That is all.
Any other submissions?
Anyone else? No, I don't think. So I'll just deal with this minute. But issues arise out of the pleadings and the orders impugned. Now, the impugned order is at page 33. Your Lordship has seen. And I am impugning this order because it affects me. I am not aware of what the CEC is doing. I am not aware as to what anonymous complaint they have taken cognizance of to upset the entire legal situation in Kaziranga as far as quarrying is concerned. Because it is not a case of illegal mining, my lord. As your Lordship has seen, it is all legal mining because we have followed the law. The concerned authorities have examined our plan, they have approved the plan, we are operating as per that. Now, we are getting this order at page 33.
You're in the first writ petition.
Yes, this is, I think, Kadam Terang P. Same order is impugned in both the cases. This is the impugned order. It is given by the divisional first officer, suspension of mining within the proposed suspension of mining operation in the stone quarries falling within the proposed eco-sensitive zone and Kaziranga National Park and within default economy zone of Kaziranga so-and-so, decision of the meeting dated so-and-so, chairmanship of so-and-so, CEM, CEM is the council chairman on the matter related to mining in the proposed eco-sensitive zone of so-and-so. In pursuance of the above, the mining operation is suspended with immediate effect under Parka Pahar range jurisdiction for the stone quarries falling under the proposed eco-sensitive zone of national park and within default EFG ANP in compliance of the Honorable Supreme Court's order in this regard. In view of the above, you are directed to ensure that all concerned quarry holders stop mining operation in compliance or ban on mining in such areas as per the Honorable Supreme Court's order in this regard. To all concerned settlement, this is the order. So what do we find, The council is telling the officer to pass an order of suspension. Let me assume for a second, without disputing, but not conceding, that he is the competent officer. Now, how does he suspend? The Act provides for a provision, Rule 6. So if that is not given, we are before your lordship. We are not given any opportunity. We are not given any, and what are they doing? They are saying that these stone quarries within the proposed eco-sensitive zone, that's why your lordship's query is very relevant. As your lordship said, what is this proposal? Are these within the proposals? Has your lordship got that answer from the elaborate affidavits they have filed? No, they can't. That is on the merits. But the procedural part is that you have not even given us that opportunity. We would have shown that proposal you have sent is different. It doesn't cover our area. Where is that opportunity given? By whom? CEC is taking on the basis of an anonymous complaint. And whole thing is revolving around that anonymous complaint. If your lordship sees that notification of creating the CEC at page 327, can he take note of an anonymous complaint? Kindly see it for a moment, 327. Which has been placed by my friend. It is the constitution of the CEC. We all know what is happening in CEC. 327. Rule 2, the committee shall exercise the following powers and perform the following functions. Kindly turn to B. To deal with any applications made to it by any aggrieved person. An anonymous complaint, can it be said to be an aggrieved person, Miller? The whole thing has started for a thing which is obvious now. Now, I am not concerned with that. I am concerned with you are saying two things in this impugn order. That these stone quarries fall within the proposed eco-sensitive zone, therefore we are doing it. Two, it is against the Supreme Court judgment. Now, Supreme Court judgment, they have annexed in their affidavit 3. It doesn't concern us. There were one of 2019, which I showed that it was given and implemented when we were shifted out. Therefore, that part is over. This is a separate, fresh initiation. The procedure was followed. The concerned authorities have found our mineral plan to be to be in compliance of the law, and we were allowed. And we are doing it until this day when it come. Now, it says that it is within the stone quarry is falling within the proposed eco-sensitive zone. You have not given any opportunity to us whether we fall within that or not. You yourself have given a proposal which is under consideration according to your own affidavits before the central government. You don't indicate to the Honorable Court what is the distance you have determined or suggested in those proposals. Why? They are giving 300 pages of your documents, and the relevant thing which is being mentioned in the impugn order, they are not giving. Ask them to produce. I can understand the submission of the council that we have a power of review, we will reconsider. Very good. Do it. Keep the matter pending. We'll, if your lordship directs, we'll file our version and let them satisfy us that we fall within their proposal. Simple matter, my lord. Keep it pending. 2 weeks' time, your lordship will give. Let them consider and see whether it is within this proposed eco-sensitive zone. If it is not, why should we? Entire lot of people, 11 or 12 people are affected by these orders.
Yes, my lord. Then we can pass a short order.
My lord, whatever the grievances that may have, my lord, they may submit a representation to us. We'll review.
We'll do that. Let the matter be pending, and they should give the decision
Period, my
within
lord.
12
They
days.
just submit a petition within a week, my lord.
Ah.
After 2 weeks' time may be granted to us.
Okay, we'll file that within 1 week. And we will take this only, this impugn order as the offending order, and we'll attack and say that.
Both the orders are the same date.
Same. Same order, no? 10 or 11 queries were stopped.
Well, only in respect of the petitioner, my lord, not the others.
No, I am only talking about these two petitions.
Only the two petitioner.
Of course.
Okay, take down. The petitioners in both the writ petitions are aggrieved by the communication dated 29/1/2025 issued by the Divisional Forest Officer, Karbi Anglong East Division, Dipu, directing the range officers of Northwestern Range, Parkup Pahar to suspend all mining operations in the stone quarries falling within the proposed eco-sensitive zone of Kaziranga National Park and Taipei Reserve, and within default ESZ eco-sensitive zone of KNB and TR in compliance of the Honorable Supreme Court order. Stop. During the hearing of the during the hearing of these two writ petitions, Mr. J. Chutia, Learned Standing Counsel KAC, submits that there is a provision under the Assam Mineral Concession Rules, 2013, particularly
Rule 67.
Rule 67, which provides for a review by the by the Director oblique Principal Chief Conservator of Forests
Or the council.
and Head of Forest Force, Assam.
No, my lord, as the my lord, it is a transfer subject,
Hmm.
the autonomous council lordship may aid that.
Assam, stop.
The autonomous council will be the proper authority to.
He submits that as the present matter is a transferred subject to the KFC, the authority would be the autonomous
Karbi Anglong Autonomous Council.
Karbi Anglong Autonomous Council. Stop. He therefore submits that if the petitioners in these two writ petitions make their respective applications
Along with the relevant documents.
along with all their annexing all the relevant documents, the concerned authority would review the matter within a specific period of time. Stop. Para. Mr. P.K. Goswami, the senior counsel, fairly submits that the petitioners in the two writ petitions would file their respective applications by enclosing all the relevant documents before the Karbi Anglong Autonomous Council.
Before the my lord secretary, Environment Forest Department, Karbi Anglong Autonomous Council.
Before the secretary.
Respondent number.
Give the name
Respondent number 15.
before the
Respondent number 15. 15, madam. Secretary, Department of Environment Forest.
then in that other one also we can do that
My lord, my lord.
before the secretary, Department of Environment and Forests, KAC Dipu within a period of 1 week from today. Stop. Para. Considering the submissions made by the learned counsel for the parties, the petitioners in both the writ petitions are directed to file their applications for review by annexing all relevant documents in the said application within a period of 1 week from today. Stop. 1 week from today, before the secretary, before the Secretary Department of Environment and Forest, KAC, Dipu oblique respond number 15. I said 1 week. Within a period of 1 week from today. Stop. Para. Draft on receipt of the application to be on receipt of the application to be filed by the petitioners, the respond number 15 shall consider the application for review by giving an opportunity.
Done by the council. He is the secretary below. The council has to consider the matter. We will file before the respondent files secretary. He will place it before the
Authority.
Draft the respondent number 15
Council is the.
shall place the matter before the
Authority of KAC, madam.
Before
that
the
much
chief
will do.
executive
That will do, my lord.
Before the chief executive.
Before the CMT member, that is he is the my lord, chief head, my lord, but he is a political person. So my lord, lordship authority of KAC.
No,
Therefore,
he is the chief of the
chief executive member.
council below.
My lord.
He.
Before the chief,
Executive
before the
member.
CM,
CM.
KAC,
Yes.
forthwith. After the CM, KAC shall consider the appeal or the review filed by the petitioners after giving an opportunity of hearing to both the writ petitioners within a period of 2 weeks from the date of receipt of the said applications for review. Stop. 2 weeks would expire. After 3 weeks, it will be
My lord.
We'll file within 1 week and they will dispose within.
1 week will be the next week. Then 2 weeks. Then we can have it on 30th of April.
Lordship can dispose of it also if you are not
No,
reviewing
no,
it.
let it be pending.
I think there will be a fresh cause of action. If
The outcome of the consideration of the application for review
Communicated to the petitioner.
shall be communicated to the petitioners. And also before the and also the same shall be placed before this court. Placed on 30 April.
Deeply obliged. কি নামটা ডেট
We passed the order in the two petitions, sir. Common order.
Yes, in both the petition. People.
Or separate orders with us. Don't say petitioners, let's say petitioner in the present litigation. Huh?
4, 5, and 6.
Please, Your Lordship.
Yes.
These are all on the same line, Your Lordship. Now,
Lordship, before any time is wasted, and my due apologies to your Lordship as well as the senior counsel. So can this matter be taken up after some time, if possible? Actually, there's a patent matter going on in court number 9, might take some time, and Counsel G. Gogoi is handling this matter.
Okay. After some time.
means,
Will he conclude his arguments today?
that is what I'm saying, because he is tied up out there, so whether he will be able to come,
That I'm also not sure. I went upstairs, he's on the argument stage.
then a date may be fixed here because
Okay.
it would be uncertain, Your Lordship. as to that.
Third, Mr.
A. Biswas.
Biswas, Learned Counsel for the petitioner.
On
On
24th,
request made by Mr. On behalf of Mr. B. Gogoi, Learned Standing Counsel TWT. List these matters on
24th, if Your Lordship, next, after the vacation, Thursday, Your Lordship. Obliged, Your Lordship.
7.
My lord, before I take your lordship to the annexures to demonstrate my case, my lord, the case in nutshell is this, my lord. There was an NIT issued with certain condition A, B, C, D. There is a clause which says that if you want to deviate from any of the condition, then you will have to submit a deviation statement, that what condition you want to deviate from. So, my lord, we were not agreeing to 2 or 3 conditions. So while submitting our tender, we submitted a deviation statement. So look, A, B, C, we need a change. With this change, if you want to accept our tender, please accept it, otherwise we cannot. Upfront, we have given it, my lord. What they have done is this, they have accepted my tender, issued a letter of acceptance in my favor without considering my deviations. This is 1. 2 is that they have changed certain conditions of the tenders. In the tender document, the conditions were, say, for example, A, B, C. While issuing the work order, they have given condition X, Y, Z. I write to them that your letter of acceptance can at best be construed as a counter offer, which I reject. Because, my lord, either you accept the bid as it appears or you reject it. There cannot be a conditional acceptance. That's my case, my lord. Thereafter, what they have did, they have come up with a penalty notice because I refused to do the work because they have changed the tender conditions. They come up with a penalty notice that 40 lakhs will be deducted from your security deposit and all those things. We have assailed that order. Now I take your lordship to the NIT first. My lord will kindly come to the NIT at page number 25.
Yes.
This is the NIT. The work is basically, my lord, for supply of elastic rail chip.
Where is that?
Page number 25, my lord will see. That's the NIT.
Which is dated?
The NIT is dated, my lord, 6/12/2021.
Where is that?
My lord may kindly come to page 25, where they have, this is the closing time. They have mentioned that the opening date, your lordship will find it at 6/12. Yes. Publishing date on the right-hand side, my lord. On the right-hand side, middle, my lord, first table, right-hand side, middle, publishing date, 6/12/2021.
Okay.
Now, this is the NIT. My lord may kindly come to page. Initially, I'll show, my lord, how they have changed the tender conditions. Kindly come to page number 25. Sorry, my lord, page 34. Clause number 25. This is price variation clause. This primarily means, my lord, if after acceptance of the tender, during execution of the work, if the prices of the material varies, then how that price variation will be calculated. The formula for price variation for is, your lordship will find at page 38. My lord has seen there are certain marks given as A1, B1. My lord have seen those marks.
Yes.
My lord will kindly see this. Wholesale price index for input into steel making as prevalent at the time of 10 days prior to call of inspection of ERCs. So these are, my lord, these are the how they will calculate, which will be the base price which they will take. Suppose the price have escalated from 10 rupees to 100 rupees during execution of the work, a base price has to be first ascertained. What would be the base price? So the method of calculating those base price is given as prevalent at the time of 10 days prior to call of inspection. Then B1, 10 days prior to call of inspection. These 10 days prior to call, your lordship will see this is common for all the materials. Steel, iron, steel semi, finished steel, fuel and power. A1, B1, C1, F1, L1. These are for different materials. They have given a particular formula in the tender notice. Now, my lord, what they do is this. My lord will kindly come to page number 59 regarding the deviation clause. Page 39, my lord, kindly page 39 forward.
Yes.
Deviation clause, my lord has seen, clause number 26.
Yes.
My lord, I'll read this, my lord. In case intending tenderer desires to quote deviation from the tender condition, the tenderer should attach deviation sheet along with his offer and should indicate the cost of withdrawal of each such deviation sheet quoted by him. In case where the firm does not submit any deviation sheet, it will be taken that the firm has accepted all the terms and conditions as per tender condition. That if I do not submit a deviation sheet, it will be construed that I have accepted all the terms and conditions of the sheet. So therefore, my lord, my purpose is to show that there is a scope for deviating, provided, my lord, at the time of submitting the tender, I furnish a deviation sheet. My lord, the deviation clause is further reiterated at page number 54. My lord, clause 1.1. This is instruction to e-tenderers for manufacture and supply of PUA fittings. The tenderers are requested to carefully go through this instruction and all the condition as mentioned in para 1.3 and 1.4 appended herein below. By submitting the quotation, they undertake to abide by all types of condition at para 1.4. The tenderer's digital signature on the e-tender form will be considered as their confirmation that they have read and accepted all the conditions laid down in the tender as well as tender schedule, comprising of techno-commercial offer from including special condition of contract for e-procurement of track fitting attached to e-tender and financial offer form. Now this is important, the rider is this. Unless specific deviation is quoted in the techno-commercial offer form. So if I sign once my digital signature appears in the tender form, my lord, it will be construed that I have accepted all the terms and conditions unless there is a deviation sheet separately attached to the tender. Now, my lord, we'll kindly come to our bid, which is starts from page number 100. This is our bid, my lord.
Yes.
Now, the deviation statement which we have submitted is at 107. My lord is there. My lord will see Kalimata Vyapar Private Limited, that is the petitioner's company. A commercial deviation, my lord have seen that commercial deviation and special condition against tender number, these are there. Delay in inspection.
Yes.
Delay. If there is any delay in inspection beyond the 7 days from the date of submission of our call, the delayed period shall be counted to railways account and DP should be refixed accordingly. Then 2, non-availability of raw material by Rashtriya Ispat Nigam Limited. In case of non-availability of raw materials from Rashtriya Ispat Nigam Limited during the currency of the contract, since our offer is based on the approval of Rashtriya Ispat Nigam Limited as an approved vendor, 23 mm dia spring steel round, such and such, and if there is any delay for execution of the contract, such delay will be on railways count and DP should be refixed accordingly. DP means, my lord, date of completion, my lord. We shall not be able to supply the material within the DP until or unless the raw material is manufactured and supplied by RINL on regular basis, since ERC manufacturer are only dependent on RILC for procurement of raw material, because this is the company which is approved by the railway. Only the materials which are manufactured by this company has to be supplied. So we say that these are the 2 conditions which you will have to accept if you want us to execute the work. Now, my lord, what they do is that page number 113 is there. Now, 109 is their letter of acceptance. Now, in their letter of acceptance, they don't write, they don't consider our deviations. And what they do is that they change the condition of the tender, which your lordship will find at page number 110.
Yes.
Now, my lord, will kindly juxtapose page 110 with page 38 for a while. That is the formula which I have initially, my lord, that price variation formula, which was there in the tender document, which I have already indicated, my lord, page 38. My lord will see this A1, B1, they have changed the condition. Now the condition reads as this: wholesale price index for inputs into steel making as prevalent during the month just preceding the month of issue of call letter. And in the tender document, it was 10 days prior. Same with metallic iron, same with mid steel and all this. A1, B1, this will be clear, my lord, if your lordship places page 110 and page 38 simultaneously. Your lordship will see they have changed the condition. So therefore, what we have immediately on receipt of the LOA, we say that your LOA is not a letter of acceptance. It is at best, it can be constituted as a counter offer. That we are offering you this. Now, whether you agree, we don't agree. That is our limited case, my lord. Because an offer has to be accepted in totality. There is a judgment I'll place, my lord. There cannot be a conditional acceptance. You come up with a tender for supply of apples and I quote rate accordingly, and you give me a work order for supply of oranges.
Okay. Continue.
Probably your lordship will be.
Item number 10, we talk about for the day, my lord. We take on 8, my lord. Not doing, my lord.
Okay, and request made by AGRTL and comes to the list after 1 week. 1 week.
On 8, my lord.
You are adjourning the matter. I can't fix the dates. After 1 week.
Item number 8, my senior went at his native place out for some personal difficulties. Kindly adjourn the matter for the day.
Item 8.
Yes,
Who's your senior?
at Sahu.
On request made on behalf of Sahul and council. List after 1 week.
After Bihu,
After 2 weeks.
May it please your lordship. So therefore, my lord, your lordship has seen that the letter of acceptance which was issued, they have changed the terms of the tender in the letter of acceptance. My lord, the letter of acceptance, which is at page number 109, is dated 1/4/2022. Within 3 days, my lord, may kindly come to page 112. My lord is there at 112. Within 3 days, we have written to them that your referred letter mentioned under reference 2 is not a letter of acceptance. It is a counter offer only, hence it is rejected. My lord, notwithstanding our rejection, my lord, what they have done is thereafter they have issued the purchase order, my lord, which is at page number 113. They issued purchase order. Then, my lord, page 118, your lordship will see we have given a detailed reply stating the reasons that we had submitted the deviation statement. We don't agree to certain terms and conditions. And therefore, my lord, since you have not accepted to those deviations, your letter of acceptance cannot be construed as an acceptance in the truest sense of the term. In fact, it can at best be.
Purchase order is dated?
My lord, purchase order, your lordship will see at page number 112, 113. Purchase order is dated 27/4/2022. PO date. Now, my lord, in response to our letter, which is at page number 118, they write to us at page 124, my lord will kindly see. Here they quote half of clause, para 1.1 of the instruction. They don't quote the complete instruction. My lord will kindly see page number 124. The second para, which starts with the word moreover. This is Railway's letter, my lord. Moreover, in para 1.1 of instruction to e-tenderers for manufacturer and supply of PUA fittings, it is clearly mentioned that the tenderer's digital signature on the e-tender form will be considered as their confirmation that they have read and accepted all the conditions laid down in the document as well as tender schedule. And then they said ... My lord, they have deliberately, they have not stated the proviso of this clause. My lord will kindly turn to page 54. This is from where they are quoting. The tenderer's digital signature.
Yes.
Clause 1.1. the fourth line, which starts with the tenderer's digital signature. My lord, they only quote till this tender schedule. They don't quote the later part. That is, unless specific deviation is quoted in the techno-commercial offer form.
Yes.
They deliberately omit that, my lord. (124). Then again, my lord, we had given two more replies, which your lordship, the same thing, page 127, and the other one is at page 134. We give reference to all the previous communications and we say that it is not possible because we have already intimated you within 3 days. We have said that your letter of acceptance cannot be accepted. Now, my lord, the impugned order, your lordship will find at page number 136. This is what we are challenging.
Yes.
Here, my lord, they say, please refer to this office letter under reference such and such, wherein you are requested for early supply of the above mentioned track fitting. It is seen that purchase order number such and such dated such and such was issued to you on 27/4/2022 with a delivery period up to 27/7/2022, which is expiring within a few days. You are aware that the ERC mark, my lord, these are technical things. I'll skip this para. I'll come to the penultimate paragraph, my lord. Failure to supply within 7 days, contract will be terminated with a penalty of 10% of the value of the stores not supplied. Now, my lord, the total value of the work is 4,59,01,440. So 10% would come around 45 odd lakhs, my lord. 46 odd lakhs, 45,90,144. Now, my lord, this is, my lord, my case, and now in their affidavit, what they say is that they say that they have accepted our deviation. In their affidavit, they're saying it, but in their letters, my lord, they're completely silent. Whether, my lord, they can improve their case by virtue of an affidavit, something which is not there in their administrative, my lord, communications, perhaps the answer is no. This MS Gill is an authority on that, my lord. They cannot. And their affidavit is completely silent about the conditions which they have tampered with. Because your lordship has seen that those two paragraphs, my lord, where the formula for price variation clause has been changed. It was one the formula was one in the tender condition. The formula which they have given in their letter of acceptance is different from the tender condition, which they cannot do it. So therefore, my lord, I denied I cannot do this work with those conditions. And yes, my lord, one additional factor was there. While submitting our tender, we have wrongly typed the GST rate as 4%, which ought to have been 8%, 18%, which we have clarified. But that's not the issue, my lord, that even department could have understood. The issue here is two, my lord, whether they can change the tender condition in their letter of acceptance, number one. Number two, whether they can conditionally accept my tender. My lord, I'm just relying on one paragraph of a judgment of the Supreme Court. For the time being. Para 12. My lord, I'm sorry, there is some marking in this, my lord. Para 12.
Yes.
When an offer is conditional. So, my lord, my offer was my bid. When an offer is conditional, the offeree, that is the railways in the instant case, has the choice of either accepting the conditional offer or rejecting the conditional offer or making a counter offer. But what the offeree cannot do when an offer is conditional is to accept a part of the offer which results in performance by the offerer and then reject the condition subject to which the offer is made. That's my case. Subject to what the railway says, my lord. These are my submissions.
Yes.
The basic, the initial cases, they GST, initially they quoted 4.5, and thereafter, after opening the tender, it was submitted, and after 2-3 days, it was our error, it should be 18%. This was the main case, so, the initial,
Is it your case of the GST or is it your case that the deviation chart given by the petitioner was accepted?
That part, so far, this, my friend, learned friend, placed before this, court, the page 38, price variation, is there, This is, that can be after, starting the work also, that can be, by filing separate representation, But what?
No, see, your NIT, the clause is there on the deviation clause.
Yes, as per this, as per affidavit of railway, it was considered, This our statement is the paragraph, 7 of the affidavit, The
and the other thing is you've changed the conditions of the NIT.
That things, only this. I'm reading, This, so far that part is concerned, This in when they have submitted when the purchase order was issued on 27 April 2022, Thereafter they filed a representation on 12 May 2022, This purchase order is page 117 117, Annexure 7.
Yes.
And this next, on page 118 is, this their representation, In this, here, there is no whisper, relating to price variation, Subsequently, another, the page, another, their representation, filed on 22nd June 2022, on page 127, Then this question, there is this question, Initially, only this main question, they quoted 4.5% GST, and they got they are the lowest bidder, And
Is that your case in your affidavit in opposition? Is that your case in your affidavit in opposition?
Yes, Paragraph 7, this I'm reading, The Paragraph 5, this the dependent makes stated the tender so and so, they close on 28/12/2021. Paragraph 7, this the paragraph 5 of the petition dependent makes state that the respondent authority agreed the deviation and considered for placement of an order by purchaser. Full responsibility of GST borne by the supplier. It is clearly mentioned in the AAL and PO purchase order. And paragraph 8, with regards to statement made in paragraph 6, 7, and 12 of the petition, deponent begs to state that petitioner firm is approved source the tender item, and after binding, it is bound. It is found that the petitioner firm is L1, and considering the deviation of firm, the LLA. And a letter of acceptance was issued to petitioner firm. As the petitioner firm is L1, and considering the deviation of the firm, petitioner firm, the work was ordered to the petitioner firm. The question of acceptance from the end of the petitioner firm does not arise, as it was not a counter offer. Correspondence after opening of the tender is not acceptable. So, everything it is after this opening the tender, they raise this question, And so far, price variation is there, This only this. I'm reading, This is there. We cannot say this is not there,
Come to page 38.
Yes, I'm also coming. Page 38, Page 38 and page, this. Page 38 and page 110, In acceptance letter, page 110, and in tender paper, page 38, This is there, This we cannot say this is not.
But so you have changed the conditions of the NIT, isn't it? You're admitting that.
That is in record, This I cannot say this is not. This is record,
It's a matter of record.
Matter of record.
So you have changed the conditions of NIT.
That condition, this only whatever, Here, this return is like this, The whole wholesale price of index input into the steel making as prevalent at the time of 10 days.
We have read that
Yes.
earlier it was 10 days. Now you have brought it to 1 month. Yes, man, that is there, that is there, man. That is that I cannot, it is there, it is the record, man. But what happened, man, only that so far GST portion is there, man. Now it's. GST, there's not a whisper, there's not a whisper in your affidavit in a position. It is there, man. It is there, but is there anything in the GST?
GST, there was a typographical error in the.
It is
My lord,
there,
either-
paragraph 7, my lord. The full responsibility of GST borne by the supplier. It is clear, my lord. So, my lord, they claim, well, it was their error, my lord. So, my lord, it was initially when they submitted tender, it was 4.5, my lord, percent. And subsequently, then after opening the tender, they said no. When their lawyers bidder, my lord, they said no, it was our error, it should be 18%. So, my lord, see, if suppose my lord lordship may consider the case, my lord, this so far the price variation is there, my lord. Lordship may direct the authority, my lord, this whatever the tender documents is there, that should be prevail, my lord, and they will do the work, my lord, as per their GST rate reflected in their tender paper, my lord.
Oh.
Because my lord, is they are not willing to work, my lord. This first initially they are when they are representative filed, my lord. I'm reading again, my lord. This page 118. There is no whisper relating to the price variation, my lord. When the purchase order was, my lord, issued on 27/4/2022, my lord.
Where's your deviation sheet? My lord, my
107.
yes, my deviation sheet, my lord, your lordship will find at
107.
107. Yes. 107. My lord, they are trying to hijack the case.
My lord, they are-
The issues are simple, my lord. That
No.
they are, my lord.
Basic thing is, so far, if my lord, the 4.5% GST, my lord, is reflected in their tender, my lord. And they are only for that, they are not willing to do this, to do the work, work, my lord. Because others, my lord, that can settle in with the officials, my lord.
In the NIT, there was a deviation clause.
I understand, my lord. It was considered, my lord. It was in our affidavit. We said that it was considered, my lord. Page 18, page 8, my lord. Page 8, my lord. This and considering the deviation of the petitioner form, the work order was ordered to the petitioner form, my lord. Page 139, paragraph 8, my lord. It was considered, my lord. So the record will speak, my lord. Because we stated in affidavit, my lord, we are considered the division.
Okay, let us see, you have considered it, but you changed the conditions of the NET.
That is true, my lord. But so far that part is concerned, my lord. My lord, so far the only the price derivation, my lord. It was not their case, initial case, my lord.
Can I record that you have admitted that you have changed the conditions of NIT?
It was there, my lord. This petition itself speaks, my lord. It is there, my lord.
So I'll record that you have admitted. My lord, just one thing may I indicate, my lord. Just one thing I'll indicate, my lord. What they're saying now, this affidavit was filed in the year 2024 October. This work order was issued in 2022. There is nothing on record, no communication speaks about my deviation statement, whether they've considered or not. Even their communications, they're absolutely silent. During those contemporaneous point of time, the communications which they have made, they're silent about any acceptance of my deviation.
What is your prayer?
My prayer is to, my lord, now it is already, my lord, 3 years have elapsed, that penalty part must go, my lord. That 10% penalty part must
That is only
go.
there. They escape from the work, my lord.
Okay. I'm deeply obliged.
But Mr. M. Biswas, counsel for the petition, as well as SK maybe, then the CBC, but we will conclude just one reason.
What is this IA? No, my lord, this IA that was, that IA was for some correction of cost, it is done, my.
Item 1, motion.
Which one is this?
Daily life.
Oh, yes, yes. Well, this matter was moved on 28. I'm sorry, I'm to petitioner. No, I'm sorry.
Sir, most welcome.
So your lordship is directed the government advocate to get hold of that, my lord, pre-bid meeting resolution.
Correct.
Yes, correct. Because entire thing depends on that. Whether, my lord, it has come or not, I don't know.
Preparing for the municipal board matter. Instruction I received and just. Well, the one I like matter.
Flex mark.
I have given the paper chronologically. Now, on 11th, not it was not a 9C matter as has been reflected in the order. On 11th, it was 25. All the contractors, so bidder participated in the tender process. matter.
Have you given a typed copy? Translated copy?
No, I have not given.
I have a typed copy of that document.
You know, the icon.
Right.
That's a typed copy.
Well, there is no proceeding, only the signatures are there, madam.
Okay.
Signature of petitioner?
Yeah, petitioner signature is there, madam. So 11th of March 2025, madam, there was a pre-board meeting, pre-bid meeting, madam, with the contractor. And after that, on 12th, next day, the petitioner submitted his bill. But before that, your lordship may kindly come to the previous page.
Previous
Previous
page
page.
of your instructions.
Of the page 4, madam. It is also reflected in the last order, madam. On 5th of March 2025, madam, the board took a resolution, madam. May I read it, madam? The board discussed the settlement of Bhim Bazar Adda for the year 2025-26 based on the Assam Cabinet decision held on 2010, which stated as follows. Any bidder can quote a maximum of 10% above the government value of the market, bazar, ghats, etc. Any bid above 10% will not be accepted. Now, there is a cabinet decision, my lord, that those who bid higher bid, my lord, they do accuse on the small bid.
That was with regard to some other department, isn't it?
PNR deal, Panchayat department.
Panchayat department.
So considering that there is a cabinet decision all ministers are there, my lord. From that, lordship may kindly see the first page, page 1.
Correct.
that-
That I see.
So, my lord, the thing is that this was binding on us, and this was very much in the knowledge of the institution also. And a resolution was taken. Then they were called for the pre-bid meeting. And the next day they have, knowing everything, my lord, they have submitted the bid, my lord. So it is not a fact that, my lord, the petitioner was not aware of this condition, my
On that 11th of March.
lord. Yes. A bid was submitted on 12, my lord.
No, bid was submitted the 11th of March. Petitioner was there.
Yes.
It was there, my lord. As serial number 7.
So if they can just produce the minutes of what had happened in that meeting.
But that is.
Because
not
on 11th, it was only for extension of that particular date. I have those documents with me
So
also.
why extension? Because the board has accepted the resolution of the state. My lord, it's a decision-making process which is under challenge. What your lordships wanted to know was whether he was aware that corporate board is going to implement this decision. If he was aware, he should have challenged that. Having participated, now can he come up with all this plea? Now today they have filed an affidavit saying we were not aware of all these things. And that is the precise reason.
You filed an affidavit.
So I have an affidavit. That is not an affidavit in the court and notarized affidavit. So what had happened on that day, on 11th, was a meeting wherein they wanted to extend the last date of submission. This issue of 10% was never discussed. If it had been discussed, there should have been a minute of that. What is not in existence before lordship cannot presume that. A meeting which that was held, maybe for hundreds of reasons, but being an authority, a statutory body, they have to justify their actions based on written documents. They cannot make statements in the open air, in the thin air and say, we have discussed that. If they have discussed, let them show that they have discussed. Where is the minute? In fact, I have documents with me, if I may just place these documents. The executive officer, who is a government officer, states that there is no minutes on that day. In fact, people who have attended that meeting have filed an affidavit, notarized affidavit, saying that day the meeting was only held for the purpose of asking for extension, because circle officer was not there. If this 10% issue was discussed, why is it not in the minutes? Why they have not made a minutes? How can they simply make a statement in thin air and say that we have discussed this issue? And another aspect, lots of people see those documents and I'll just submit. Five or six people who have attended that meeting on that day say it was only for that, because on 11th, if you are bringing up such a big issue of this 10%, because you are changing the game, once the game has begun, in the midway you're changing the game. If that be so, why there is not a corrigendum to that regard? Why they have not minuted it? If on 11th, because 12th is the last date, if on 11th you are breaking such an important news before the tenderers, why was it not minuted? The NIT does not have a pre-bid date. The NIT doesn't have it. So how do you know that the public at large has come to know that who is going to bid the next day? They all have the knowledge that the authorities are doing something of this scrubbing, that of bringing a ceiling of 10%. There is no corrigendum. They have not minuted the 11th meeting. So how, and one more very important aspect, Lordship will see. If a Lordship takes up that document that I have given a type copy, the translated copy, the original, if a Lordship will take it up. Lordship has seen that these are all businessmen who have participated in a tendering process and they are now fighting tooth and nail for that market. They cannot be such a fool that they will attend the meeting. They would be informed about the same and still they would insist in giving a rate that ultimately would lead to their cancellation. Here, if a Lordship will see, Suryakanto Bora, he was the highest, H6, number 3. This document I have also given in red ink. I have stated that this space. I've given this space twice, Lordship will see that. No, in the middle portion.
Anyway.
Yes, Lordship will see that third name, Suryakanto Bora. He was H6. The fourth one, Hidoy, he was H1. I have given that, so I've just marked it. Have you seen that? Then Keshav Kolita H2, Vidyut Jyoti found H3. Lordship will appreciate that it is the H7 who has been given this award of settlement. That means from H1 to H6, they knew, still they don't give that rate within the 10%. Can it be presumed that way? The presumption always has to be in my favor. Because if they are saying that it was discussed, there should have been a minute. A statutory body and a statutory act cannot make submissions in thin air and say, there was a meeting and in the meeting we had discussed. If it was discussed, there is no minutes of that. So therefore, the presumption cannot be against it.
According to you,
Lordship.
if the 10% increase
Lordship.
was is not mentioned in the tender notice.
In the tender notice.
And therefore, in the pre-bid meeting also on 11th, there was no discussion on that issue.
There is no discussion
So
on
the
this.
highest bidder should get the.
Yes, Lordship. The highest bidder should have got it. At best, the one who is more deserving has to get it and not H7. Because I had also placed certain judgments with the Honorable Court on the last date saying that price cannot be an issue.
So you were the highest bidder?
I am the H2 bidder, Lordship.
H2. And who's H1?
H1 has not come before this court. So maybe H1 may have withdrawn also. I do not know. But I have a better claim than H7. I have a better claim than H7. To that aspect, my locus stands. Tomorrow, H1 may not come. Since he is not here with the Honorable Court, maybe he has just withdrawn from the process. But that doesn't take away my right also.
What is the present status?
No, we have taken over. It has been settled with us. We have deposited the money. We are operating the market.
Because of that,
there was
because the adjournment on the last occasion. Because of this issue.
What I intend to do, subject to your lordship's
So
message.
I am praying for a stay because this undeserving.
Let him
Yes.
finish it. I'll make this up.
There are, if I may make a few submissions, because the issue is now whether there is a stay will be given or not. And I will be pressing hard for the stay order because an undeserving person at a rate where the government is losing so much of revenue should not be allowed to continue. Also, the first issue that he has raised, my friend from the PNR, I mean, from the Panchayat, from the municipality, the first ground that he has said was that the cabinet decision. Now, Lordship has seen that cabinet decision. I may just take a Lordship to the cabinet decision. These are very relevant issues that I would like to point out. So, Lordship, kindly bear with me. Page 34.
Of your writ?
Of the writ petition. Yes, Your Lordship. That is the only pleadings on record today, Your Lordship. Page 34. Now, Lordship has seen that the cabinet decision was of 27/6/2024. Now, and this was particularly for the Panchayat department. Now, based on that particular cabinet decision, it is the Panchayat department who has issued an order, a notification under the seal and signature of the governor. And when it was done on 29/6/2024. So, this document was issued for the Panchayat department under the seal and signature of the governor. And this was done in the year 2024, more particularly 29/6/2024. Now, this NIT is of the year 2025 January. So there was a time of 6 months in between. The authorities at Dhing Municipality Board is governed by the municipal department. So today to adopt this circular, there has to be a notification under the seal and signature of the governor through this department of municipality. The Dhing Municipal Board on its own in isolation could not have taken up or adopted this decision, number one. Number two, even if they say that, okay, we will take it up, even if our parent department doesn't say anything, in Dhing Municipal Board, we will go ahead with this decision of 10% cutoff. Who were stopping them from putting it in the NIT of January 2025? Because the decision was of 2024, June, 6 months in between. They don't do that. They don't do that consciously because they want to take us by surprise later on. They want to go through this exercise of not informing us, bringing in this clause, rejecting our thing. Who were stopping them? Is it a action that will be judged by the lordships as to be a proper decision on their part? If they say they are adopting it, who were stopping them from putting it in their NIT at the very first place? Who were stopping them from bringing a corrigendum later on? They don't do that. How they are trying to justify their action? On 11th, we had a pre-bid meeting. Does your NIT have a pre-bid date? How will the tenderer at large know that we will have a meeting? How did they select these persons who were to be there on that meeting? I might have been a tenderer. I do not know. I was not given a notice to that effect. I might have also participated. So therefore, normally in NITs, there is a pre-bid date given, number one. This NIT doesn't have a pre-bid date. So they say they issued certain notices to some people here and there. And based on that, 10 persons have attended. Out of that, 5 persons have filed this affidavit lordship, notarized affidavit saying that the only discussion that took place was regarding the extension of the date. Should it not be 12, it should be some other date, which they didn't accept it. And thereafter, based on that, they say that it was informed. If it was informed, who were stopping them from putting it in writing? Why is there no minutes? Why is the government officer, the executive officer, states under his seal and signature that there was no minutes of that day? How could the statutory body rely on this and say this was told to us? How will your lordship presume it against me? How will your lordship hold it against me? The other issue then thereafter.
The only issue is, see, you're just passing on papers from one side from the other side.
Yes, lordship.
What I suggest is, now the whole thing is all clear.
Yes.
Let the affidavits come.
Yes.
So till then, the market should be run by the Dhing Municipality Board.
Now the other side is saying that they've already collecting the what you call tax.
No, Lordship.
They're operating the
Yeah,
market.
Lordship,
you are operating the market.
Lordship,
So we can have it on Monday or Tuesday and
Lordship,
discuss
the
it
only,
later.
the only thing is, Lordship, they have taken over settlement on the 1st of April. And till now, they are yet to collect because the market is not there today. And it is only because of the submission that came on that day that there is a pre-bid meeting. Therefore, your Lordships were inclined to pass it over. And thereby, that way, if my prayer for interim is frustrated, in my humble submission, that will be an unfortunate situation in the given facts and circumstances of the present case, your Lordship.
Okay. Yes.
Yes.
And another aspect, just a moment.
Let him complete.
And another aspect is that the bidders who had participated in that so-called pre-bid meeting, which was only for extension, out of that, 4 bidders or 5 bidders I have shown to your Lordship had quoted above 10%. Prudent businessman, if informed on the very other day that we will not allow bids beyond 10%, could not have quoted a rate that is beyond 10%, thereby exposing them to a cancellation, and therefore Lordship will not presume it against us because they cannot show a minutes. Statutory body without a minus in thin air making a submission. That should not be allowed. And therefore, it's a fit case. Lordship will stay and interfere this settlement because he is an undeserving candidate running a government market. State largesse has been given to an undeserving person, should not be allowed, Lordship. Illegality perpetrated should not be allowed to perpetuate. That is my submission.
Yes.
My lord, the issue before your lordship is whether lordship will pass an interim order today or lordship will decide the matter. Now, there is no settlement in his favor. So therefore, he cannot have any benefit. So just to have some sadistic pleasure, there cannot be a stay order. If your lordship is to pass a stay order, it must have bear some rationale. Now, what is the rationale? That there was no pre-bid meeting, there is no agenda. My lord, section 114E of the Evidence Act clearly says there is a presumption of legality in favor of official act. It is for the other party to establish it. So he can establish it only at the final hearing. Today he cannot establish what is right, what is wrong. So my learned friend was harping the presumption is against him. Presumption is in favor of official act. Please have a look at section 114E of the Evidence Act. The presumption is always in favor of official act. It is for the party who alleges to the contrary, it is for him to establish.
First, you will also see illustration 111Z. What is not in existence cannot be read into it. 111Z.
Kindly see E, my lord, 114E.
Yes.
So therefore, now we'll notice one code.
Z also.
Now, my lord, this notice was issued to all the bidders, including the petitioner. That is why he participated in the meeting. Invitation for pre-bid meeting, it was on 10th of March. With reference to the subject cited above in the letter, I have to inform you that a pre-bid meeting will be conducted on 11th March at 11:30 AM in the office of the Thing Municipal Board. Now, my lord, issue is, my learned friend says that out of some of the bidders still quoted higher rates. If they would have informed why they would not have quoted within 10%, well, it is their business. As far as our client is concerned, my lord, we were informed, I was very much present. In fact, there was a sort of a consensus. But somebody did not accept it, it is to his peril, Miller. Fact of the matter is, in the meeting, this issue was discussed, that this cabinet meeting will be, decision of the cabinet will be applied here. Now, therefore, if you are so conscious about your right, you should not have participated and straightway filed a case. That how come this is not indicated in the NIT? How come you are implementing? That you have not done. Now, my lord, the petitioner is the sitting lessee. Now, last year also, my lord, he quoted a very high price and got it. And he, my lord, subsequently applied for rebate. But when it comes to getting a contract, you quote a higher price and subsequently you do all this thing. Now, my lord, the third most important point in this case is,
He is the second highest bidder. Assuming your lordship finds substance in what my learned friend is submitting, interferes with my settlement, it will not go to him. It will go to the highest bidder. So that is why, my lord, the balance of convenience does not lie in his favor for an interim order. Well, I'll give a small example. Supposing I apply for a post. My name is in 2. Person in 4 is sought to be given an appointment. Number 1, he doesn't come. Supposing tomorrow I succeed in the writ petition, job will not come to me. Job will come to the person whose name is at serial number 1. End of the day, my lord, it is a tender. When you submit a tender, it is only an offer that you are giving. The authority is not bound to accept your bid. Authority is not bound to accept your offer. Authority may reject it also. Only thing is, my lord, when the rejection is for arbitrary reason, then your lordship assumes the power of judicial review and interferes. But ma ki hai to kesu? 2014 SCC where the Supreme Court ma minda. 2014 8 SCC where the Supreme Court said, my lord, when a bidder offers a bid, he gives his offer. The authority accepting the calling for the bid is not bound to accept it. But if the refusal to accept is for arbitrary reason, irrationality. So what is the irrationality in it, my lord? Because it was seen that there is a, my lord, standard price. In this case, it was 7,36,000. No? 7,36,000. So authority was of the view, cabinet took a decision, whosoever costs more than 10% will not be accepted. That is the principle which has been accepted by the board. Is it such an irrational decision? Is the view of the municipal board that if the tender is given to an authority who costs more than 10% higher, is it such an irrational decision that your lordship judicial conscience should say, no, we must interfere in this case? Had it been a case, my lord, stark illegalities are committed. Lordship, I need not say now the scope of judicial review in contractual matters is really very circumscribed. End of the day, where not only mere illegality, where the illegality must be of such a nature that it must strike your conscience, then only your lordships interferes. Be that as it may, my lord, end of the day, public interest has to be respected. We will also file our affidavit. Kindly give us 1 week time. Immediately after the vacation, lordship fix the matter. Today, if your lordship passes a stay order, then lordships will be favoring a party who doesn't have a settlement in his favor. I can see. On the contrary, he must first succeed in the writ petition. Then what will do? Lordship will remand the matter back. Then question of giving him will arise. But today, if your lordship stays it, by virtue of his old settlement, he will continue. That cannot be permitted. And my lord, within 1 week, we will file our affidavit. Let board also file their affidavit. Then my lord will take a final.
File it within a few days. We'll have
We can do.
we'll dispose it before the
Okay, my lord. Okay.
I'll just make a short 5 minutes reply. That particular Evidence Act, if a lordship will see, 114, 114Z.
Yes.
114 illustration G. The evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. The evidence is the minutes. They are digressing from the issue. I am not saying putting a 10% cap will be illegal. I am saying without informing the bidders, putting it in the tender terms and conditions, if you do it behind our back, that is illegal. That is the irrationality. That is the arbitrariness that I am saying. Had it been there in the NIT, things would have been different. It is not there in the NIT. The authorities today make up a story in thin air saying that in that meeting, this decision was taken. They cannot back it with a written minutes of the same. So therefore, the Evidence Act, illustration G says, the evidence which could be and is not produced could, if produced, be unfavorable to the person who withholds it. So therefore, the presumption will be against the respondents because they could not produce the minutes. Where is that seat of
have a minutes?
They don't
Copy of
have
the
it.
minutes.
Executive officer says so.
They are in the CB meeting, that is the only signatures are there, minutes are not there.
That's what I'm saying. In thin air, they are making the submission, Lord says.
That is the my lord. Let me clarify, my lord. That is the minute where it was not recorded in detail.
That means it's
Well,
not.
the explanation G will come if they would not have produced this document. Now have they, since they have produced the document, there is no question of drawing adverse presumption. It's a
Okay. So
different
that
matter if your lordship, what if your lordship takes. G contemplates a situation that where he has produced the same thing. It's not a case where no document has not been produced, therefore adverse presumption has been drawn.
So can your lordship read into it that a previous meeting, they discussed this 10% issue? Can your lordship read that into it in that minutes? Lordship cannot do that.
Okay.
It is not there. Therefore, I'm praying for a stay order, lordship.
A. Sharma, Leonard Counsel. This court also heard Mr. K. Chowdhury, Leonard Senior Counsel, assisted by Mr. B. Kaushik for the response number 3. And Mr.
B. Chakraborty.
P. Chakraborty
For response number 3, 4, 5, and 6.
for the respondents 3, 4,
5.
5, and 6. And Mr. S.R. Barwa, Leonard Counsel, Government Advocate for the response number 1 and 2. Stop. On 28/3/2025, when the matter was taken up, Mr. K. N. Chowdhury, Leonard, Senior Counsel for the response number 7, submitted that there was a brief meeting on 9/3/2025, wherein all the tenderers were informed about the decision taken by the Ding Municipal Board on 5th of March 2025. Stop. Accordingly, the government advocate, Leonard Additional Senior Government Advocate, was directed to take instructions as to whether there was a pre-bid meeting on 9/3/2025, and also to produce the minutes of the pre-bid meeting held on 9/3/2025. Today, when the matter is called out, Mr. P. Chakraborty, Leonard Counsel, you are the standing counsel. No, and just appearance on behalf of the respondents. 3, 4, 5, and 6 of, and has produced some records and has and submits that a pre-bid meeting was held on 11/3/2025, wherein the petitioner was also present. Stop. He, however, submits that there are no minutes of the pre-bid meeting that was held on 11/3/2025. Stop. Para. Mr. A. Sharma, Leonard Counsel, appearing for the petitioner, on the other hand, submits that in the said pre-bid meeting that was held on 11/3/2025, there was no discussion with regard to the
10% cap.
to the 10% cap of the tender value in the Ding Municipal Board in terms of the Assam Cabinet decision, which was held on 27/6/2024. Nor was there any clause in the NIT dated. What date was that?
NIT was 24/1/2025.
24/1/2025. With regard to the pre-bid meeting, as well as with regard to the cap of 10% in terms of the cabinet decision held on 27/6/2024. Stop. Para. He accordingly submits that as the petitioner is the H2 bidder in terms of the NIT dated so and so, the the settlement in favor of the respondent number 7 should be state stop. But Mr. Ken Chowdhury and senior counsel appearing on behalf of the respondent number 7, however, submits that the respondent number 7 has already been settled with the what was
Market
that
rate. Thing market
with the thing bazaar within bracket Atkaun Hut on 1st of April 2025 and the respondent number 7 is presently operating the said bazaar stop. Para. Considering the submissions made by the parties, comma, and also particularly taking into consideration that the settlement with regard to the Thing Bazaar with Hut Count Hut has already been settled with the respondent number 7, comma, this court is not inclined to pass any interim order at this stage. Stop. However, comma, considering the urgency involved in the matter, list the matter on 10th April for final disposal, on which date, by which date the parties should complete their exchange of affidavits.
Could it be 11, Pilla?
11th is the last day.
10th also, so in any case, it will be a motion week. That's why my learned friend also would not
It's
be
a
there.
1-year settlement process, Lordship.
Yeah,
And
that's
I
right.
came before the settlement was
Okay.
taken over.
11.
10th, Lordship.
Okay.
10th.
Okay. 10th.
Let them file their affidavit before that, Your Lordship.
Yes.
No, that's what I'm saying. Before that, you should exchange your affidavit.
Oblige, Your Lordship.
Item 1 of production list, Bohari Reserve Gaon Min by Committee Limited.
The settlement of a fishery for 7 years. The Lordship looks at page 27.
Tender.
27 is a tender notice. Now, this tender notice has been issued by the Deputy Commissioner Kamrup. Lordship got it, man? And kindly see, seal tender affixing so and so of 60% revenue fisher, namely so and so, so and so. So 3B lower part Brahmaputra and 13 Rupanjali, this is the name of the fisher 3. 3B lower part so and so fishery under Kamrup district. Lordship got it? Please mark this Kamrup district. Now this copy kindly
There are 2 fisheries, is it?
yes, one is
13.
no, there is only yes. No,
you are not concerned with 13.
Yeah, no, there is only one fishery. Name is like this, my lord.
Okay.
Name is. So if you see at serial number 2, my lord, in copy, it is marked to District Commissioner Barpeta. Why District Commissioner Barpeta, my lord? There is a judgment of this court. Neighborhood under the fishery rule has not been defined. So I was in that part of that case, which I have annexed. So when it flows, suppose the Deputy Commissioner has put in a tender, Kamrup. Now that fishery flows from Kamrup to Barpeta. So not necessary that a neighborhood of Barpeta district cannot participate because it flows from Kamrup to Barpeta. So that was the issue I have annexed that. That's the issue before a division bench. Tender floated by one of the like Goalpara Deputy Commissioner. So a resident of Bongaigaon, whether he will be able to participate. He being a neighborhood because it flows from Goalpara to Bongaigaon. So he is not debarred to participate. But he has to be from district of that area. It should fall. The fishery should fall. So this is a tender. Now kindly see the terms and condition at page 28.
Yes.
See here 2. See 2, my lord. The quotation can only be submitted by cooperative society, self-help group and NGO formed by 100% so and so the actual fishermen belong. The bidder must be a resident please mark, must be a resident of the concerned district and also neighboring people of mean. What you got it? Now, my lord, I participated in the tender process along with learned friends and other clients. Now you see the comparative statement at page 9. Because when it was announced, we noted the rates. Page 9. Page 9 of the writ petition. Page 9. I have given a chart. Please see, there are 6 bidders. First bidder, Batkuchi Development NGO, he quoted 6 crores 31 lakhs 88, but his bid was withdrawn. He withdrawn his bid. First bidder. Second is respondent number 8 in this case, Hoop Gwalpara FCS Limited, who is the settlement holder, who has given the settlement. Now his rate is 3 crores 57, valid bidder. 3 is Jonia so and so, defective. Now 4 is Palaram Pump FCS 2 crores 49, though valid bidder. And 5 is the petitioner in this case, who quoted 2 crores 33 lakhs 33,000, because there is a base price, is 12 lakhs is the base price. So this is the, my lord, we have 5. Now we are challenging the settlement issued in favor of respondent number 8, who is serial number 2, and also because maybe he is not a settlement, is in favor. Tomorrow he may come and say that no, your lordship may put a question to me because number 4 is there, he is a valid. He is also not entitled, even though he has not been settled with the fishery. Our whole issue now is again serial number 2, he is respondent number 8. Now lordship will kindly look into it. The complaint which we made, then I will show the settlement order. Kindly see, my lord, the complaint which was made before the deputy commissioner, page 44. Page 44. They forwarded to Joint Secretary submission of cooperative lordship, got it? With reference subject, I have the honor to inform as government instruction so and so. According tender box was opened in presence of bidders. A total 6 number of bidders have been received from following bidders. In this regard, the petition dated 27/12/2024 has been received from Sri Ram Prasad Malo, that is the petitioner, regarding complaint against one of the bidders, namely Sitanath Das, that is respondent number 7, where he has alleged that Sitanath Das has submitted false caste certificate in the tender process. Again, White dated 2/1/2025, he has complained against the second highest bidder, namely Ranjit Kumar Das, Poop Gwalpara Fishery Cooperative Society, that is respondent number 8, where he has alleged society do not fall within the jurisdiction of the respective district Kamrup and Borpeta, are enclosed herewith for kind perusal and taking necessary action. Petition enclosed. It is worthwhile to mention the highest bidder, namely so and so, submit a prayer for withdrawing his bid as such company. So this was addressed, deputy commissioner addressed to a joint secretary, fishery department, which is a settling authority. Now, my lord will kindly look at page 45. We have written to the on district commissioner at Gwalpara. Kindly see that is on 19/2/2025. With due respect, I humbly submit I am the president. East Gwalpara goes so and so. The said society is located at least 10 kilometers from said fishery, which fall within the Kamrup district, specifically in northeast direction of so and so. The fishery in Kamrup district, namely number 3 so and so, are situated within the district of Nagarbera, Bagbara and Senga revenue circle of Kamrup and Borpeta district. Therefore, the East Gwalpara Cooperative Society of Gwalpara district has no jurisdiction over this fishery in the Kamrup district. Therefore, I kindly request to issue a certificate confirming that the East Gwalpara Cooperative Society is at least 10 kilometers away from the said fishery in Kamrup district, and that Kalabanda fishery does not fall within Gwalpara district. Now, this is the certificate which is issued immediately in my at my instance of the letter of 19/2/2025, CC 48, page 48. It is issued by the District Commissioner, my lord, Gwalpara.
Yes.
48, 19/3/2000. This is to certify that number 3B lower part Brahmaputra fishery 13 so and so does not fall under the jurisdiction of the Gwalpara district. The said fishery says common boundary with so and so district. Messrs. Poop Gwalpara Fishery Court is located at a distance 10 km from the shared common boundary of so and so of Brahmaputra and number 3 of so and so. So here it is stated by the district commission, it does not fall under jurisdiction of Gwalpara district. So only two falls, one is Kamrup and one is the Borpeta. Only in that district only you can participate. They become the neighborhood of that fishery. It is not necessary. The Deputy Commissioner Kamrup has issued a tender. That was the issue. I'll show it. That Borpeta neighborhood of the Borpeta fishery, Borpeta, because it flows from Kamrup to Borpeta, so he can also participate. So now that is why we written a letter to Deputy Commissioner. Please let us know whether it falls within the jurisdiction of Gwalpara district or not, this fishery. He said it doesn't fall within the district. So now, so we leave respond number 7 at present, they are not before this court, responder. Even we made an allegation against them because they are above me. Tomorrow they may come and say that no, we are above them. So we have made allegation. We are now dealing with respond number 8, who is before this court. Now kindly see at page 49. Now, when we came to know that it doesn't fall within the Gwalpara district, we communicated to the additional secretary. Kindly see. On 25/3/2025, humble submit the 6 fishery cooperative society committees participate tender process for the above mentioned fishery held on 26/12/2024. Among the tender, the East Gwalpara Fishery Court is not a recognized fishery cooperative under the concerned district Kamrup and Borpeta. This society located approximately 10 km away from the said fishery. However, we have learned, despite the fact the Secretary of Committee Ranjit Kumar has fraudulently obtained a distance certificate stating that the society is only 300 meters away and submitted it along with the tender. I'd like to bring to your attention a mean mall has traditionally been managed neighboring fishery cooperative society of Kamrup and Borpeta district since its inception. Furthermore, a certificate issued by Commissioner of Gwalpara district indicates so and so. Therefore, I request conduct an inquiry so and so. Now, even in spite of that, my lord, an impugn order was passed by the authority concerned at page 66, which we are aggrieved and we are before this honorable court. At page 66. Kindly see at page 66. That is on 28, kindly the date 28/3/2025. It appears from record that these were invited by DC so and so for fresh settlement 3B lower part so and so. From the comparative statement as well as minutes of tender committee, it appears that in response to NIT dated 6/12/2024, 6 tenders were submitted. Batkusi, my lord, that is gone because withdrawn. Poop Gwalpara is respond number 8, who is before this court. Jonia also is withdrawn. Now this 4 is respond number 7, 5 is the petitioner, and 6 is, my lord, is withdrawn. All cancelled. So now it remains only 2 and 4. And my lord, the petitioner before this court. Out of the above, Batkusi Development NGO district quoted the highest bid so and so for 7 years, but later said NGO withdrew their bid by petition dated 30/12/2024, stating ignorance about the status of the fishery resulting quoting higher financial bid. Settlement also complained to so and third highest bidder was found to be not in neighborhood of the fishery and 6 was invalid for non-submission of all required documents. Kindly now see this. Consequently, Mrs. Poop Gwalpara FCS, which quoted so and so for 7 years, emerged as a highest bidder followed by so and so order so and so bid value quoted. From the perusal record, it is found Mrs. Poop Gwalpara FCS has submitted all relevant documents in terms of the NIT, including security deposit, which are found in order. As regard the allegation against the bidder being a defaulter of government revenue of fishery under Gwalpara district, it appears from fresh Bakija clearance certificate submitted by society. Dated so in the present, there is no pending dues against the society in respect of fishery under Gwalpara district as per submission of Secretary of Society by dated 19/2. The phrase Bakija clearance certificate submitted subsequent has been accepted as a curable defect because there is a judgment of this court. Bakija is always a curable defect. So this is what he said. Now we are on the second paragraph. As regards jurisdiction of the fishery under Gwalpara district, tender inviting authority as well as settlement authority did not find any defect in a neighborhood certificate issued by CO Matia, that is Circle Officer Matia, under Gwalpara district, white dated 21/8/2024, which certified the society is located within 300 meters of the fishery in question under Gwalpara district, as it was issued based on a report of so and so in terms of clause 3 of government notification dated 18/1/2018. So what it says, my lord, there is a report which was called for from Matia, that is a circle officer under Gwalpara district. He doesn't state that whether it is a neighborhood. What he said it is 300 meters of fishery in question under Gwalpara. Lordship has looked into it, that only can be a participant, only you can participate if it flows. It has to be neighborhood of that fishery. It is not that you can't say 300 meters. This is not the case. Now, in this kind of settlement or took into consideration the submission of Secretary of so and so by representation dated with a copy of the order of the Honorable Guwahati High Court, where the order of the Honorable Division Bench, while the writ appeal has been discussed, particular para 27 on neighborhood issue relating to one fishery under Gwalpara district, having dual jurisdiction under Gwalpara and Bongaigaon district. Operative part of the judgment by para 27 is quoted here. It is therefore held that it is beyond the purview of the Assam fisher to restrict the definition of neighborhood only to territorial limits of any particular district, excluding the participation of fishing society who are situated within the vicinity of the concerned fishery, but within the territorial limits of any neighboring revenue district. I'll pause for a moment. My lord, why this propped up division bench? I have annexed that. Neighborhood has not been defined in any of the fishery rules. That is why I said, my lord, Bongaigaon, Gwalpara. If a tender is floated by Bongaigaon, whether a neighborhood of Gwalpara can participate or not, that was the issue. That was decided. That yes, it can be participating, but you cannot come from another district. This is what he was, CO Matia, he cannot be above the deputy commissioner who said that it is not in the district of Gwalpara. Now kindly see, in case of, now kindly see this paragraph. In case of Puk Gwalpara, in connection with settlement of instant fishery, it is seen fishery originating from Kamrup district ends in Gwalpara district after crossing Borbera district. It is obvious that in view of the order of observation of so and so quoted above on neighborhood issue, quantum area of fishery falls within an area within a district is irrelevant. So what he said, district is irrelevant, but district is a main. How it can be irrelevant? I'll show it. Judgment as thus, after consider all careful consideration of material in hand in judicious manner, government if is given settlement authority of so and so. So they say it may settle for a period of 3 years. Now please look into the judgment of this court at para 69, which they are trying to interpret. And they said that what is a neighborhood? They doesn't decide, they doesn't say anything on neighborhood. Now kindly see at 69. What was the issue? 69. My lord, I was there as a counsel for the other side in this case. Now see at 16. See page para 16 at page 83. 3 paragraphs and with conclusion. 16 at page 83. The third ground on which the bid of the respondent 8 was rejected, lordship got it, was that it did not fall within a neighborhood of the fishery as the cooperative society registered in the district of Bongaigaon as a distance certificate issued by the circle officer so and so Abhaipuri. The distance certificate issued by circle officer certifies that Malegar Govindpur Fishery Cooperative Society Limited is situated at village so and so under so and so is adjacent to 1/77 Digdar Divisional Forest Officer Sadar District Gwalpara, stating on record the fishery concern flows through both the Gwalpara and Bongaigaon district. Although page 85. 84. Oh, sorry, page 84, my lord. Sorry, it is my lord. Sorry, it is 17. It is strenuously urged by the Lordship got it. It is strenuously urged by the applicant for consideration of this court that neighborhood of the fishery, as mentioned in clause 2 of notice dated 24/5/2018, will only mean neighborhood of the fishery within the district of Goalpara, as the NIT issued by Deputy Commissioner Goalpara, and thereby debarred a respondent society from participating in the bidding process. The contention of the appellant is that since it is a Deputy Commissioner Goalpara who has initiated the tender notice, the term neighborhood will mean only those fishing societies situated within the district of Goalpara in the neighborhood of the factory. That's what I said, my lord. If it is Kamrup district, not necessary that has to be on Kamrup district. Now, kindly respond number 8. See, respond number society, a registered cooperative in the district of Bongaigaon. In order to decide this issue, it is necessary to understand the meaning of neighborhood in the context of the Assam fishery rules. See 18, ma'am. To ascertain as to a territorial limit, extent of the concerned fishery by our order dated 7/1/2021, both the Deputy Commissioner of Goalpara and Bongaigaon were directed to file affidavit to bring on record as to whether the concerned fishery 177 so and so falls within the jurisdiction of district of Goalpara, or is it divided between district of Goalpara and Bongaigaon. It in deference to the order of this court, an affidavit was filed by a subdivisional officer Sadar district Bongaigaon, where it is stated that the said fishery falls under both the Bongaigaon as well as Goalpara as per joint verification undertaken. The said affidavit encloses a report of survey conducted in this regard. A similar affidavit filed by the subdivisional Sadar district Goalpara stating that on record, fishery concern flows through both the Goalpara and Bongaigaon district, although about 80% of fishery falls within the jurisdiction of Balijan Revenue Circle of Goalpara district. Now, my lord will kindly see, that was the issue. See at page 89, para 25. 89. 25, para 25. As discussed above, the rules category do not define neighborhood. However, after examining the law laid down by this court in various judicial pronouncements discussed above, it is clear that the term neighborhood of the fishery cannot be restricted to territorial limit of a district or subdivision as the case may be. A neighborhood will have to be understood in context of the areas through which the concerned fishery flows through or is situated in. This is the issue, my lord. As is revealed from the affidavit filed on behalf of Deputy Commissioner Bongaigaon, Deputy Commissioner Goalpara, the fishery concerned flows to territorial limit of two districts, namely Goalpara and Bongaigaon. Therefore, to restrict fishing committee people or cooperative not registered within the Goalpara district, but who are otherwise situated in the vicinity of fishery, but are within the territorial limits of another district, will lead to a situation not envisaged under the fishery rules. The settlement process resorted to by the state authority, enhancing the revenue state, must also provide ample opportunity for the fishing committee people so and so. So now, my lord, the fishery here flows from Kamrup to Borpeta. Now, Deputy Commissioner said that it doesn't fall in the district of Goalpara. How you can participate? The respondent is from Goalpara. He cannot participate. If he would have a neighborhood of Borpeta, then the situation would have been different. So that is my case, my lord. In view of the judgment of this court, neighborhood, even though it is not been defined under the fishery rule, by way of a judgment of this court, it has said that this is what neighborhood means. So my respectful submission is this, my lord. The neighborhood, as now decided by division bench of this court, now this fishery falls only to Kamrup and Borpeta, not to Goalpara. And even one sentence of the settlement, that doesn't mean ends. My lord will kindly see the settlement. How it is that you cannot, this Deputy Commissioner has given a certificate, it doesn't fall. See page 67. It doesn't, my lord, second paragraph, the as regard jurisdiction of fishery under Goalpara district, tender inviting, lordship got it, as well as the settlement author did not find any defect neighborhood certificate issued by CO Matia under Gwalpara district, why dated 21/8, which certified the society located within 300 meters of the fishery in question under Gwalpara district.
Where's the deputy commissioners?
Deputy Commissioner, kindly see. At page 45, 48. See 48. First line, my lawyer says, this certified that so and so does not fall under jurisdiction of Gwalpara district. That's the end of the matter, my lord. Where is a question of the circle officer to interpret Matia, where it is that the 67, page 67, it says that no originating from Kamrup ends in Gwalpara district after crossing Borpeta district. So, my lord, my humble submission that he cannot participate in this tender process. His tender itself becomes invalid. In that view of the matter, my instruction, and I have written here in my submission, is that the order settlement order, though passed on 28/3/2025, my lord, the possession is not been taken over by them. The short date maybe, if that be the case, my lord, let it be stayed or status quo as on today shall be maintained. In the meantime, your lordship will hear it. That's my submission.
May it please your lordship. My lord, first come first. Circle officer Matia has not been made a necessary party. He's a necessary party. Please come to the array of parties, my lord. Because my learned friend has assailed the CO's report, so CO is not a party. So therefore, necessary party is not before your lordship. Now, what is the petitioner's case, Miller? Petitioner's case is this particular fishery starts in Kamrup district and it ends in Borpeta district. Therefore, a society which is located, let us not use this expression neighborhood area of operation, not located within these two districts, possibly they cannot take part in the tender process. Am I clear, Miller? Now they are heavily relying on page 48 order of the Deputy Commissioner. Now Miller will kindly have this. Yes, sir. My lord, this is a notification which has been issued by the government on 18/1/2018. Kindly see, my lord, under what circumstance this was issued. And this has been taken note of, judicial notice of by this honorable court in several cases. A lot of anomalies, discrepancies have been observed while verifying the tender documents forwarded by Deputy Commissioner SDO pertaining to settlement of 60% government fishery by government in the fishery department. As a result, most of such settlement orders are challenged by aggrieved parties before the Honorable High Court. It is therefore felt that there is some need for streamlining the procedure for submission of information document with tender so that there is uniformity in all such tender to notice inviting tender floated by the Deputy Commissioner to maintain transparency and avoid legal complication. So, my lord, the background of issuing notification was that there are certain documents which are involved in the process of settlement, which are being issued by authorities. At times it creates confusion, it leads to litigation. Therefore, government in its wisdom felt it that let us issue a directive under Article 162, which is, my lord, in aid of the fishery rules. And this is how this was issued. Now, please come to the, my lord, second one, 2. Same page, my lord, first page itself. 2. Neighborhood certificate. Has your lordship got it, my lord? Neighborhood certificate to be issued by concerned revenue circle officer. Only against fishermen cooperative society, self-help group, NGO, with clear indication of specific distance of the fishermen cooperative society, self-help group NGO to the concerned fishery. If the fishery falls under more than one revenue circle, then such certificates are to be furnished by all such circle officers. So, my lord, when it comes to neighborhood certificate, it is not deputy commissioner, it is the circle officer. So it is a rule. It's a power exercise under 162. Now, page 48 issued by whom? Deputy commissioner has no business. My lord, only thing deputy commissioner does is, my lord, he issues the tender. Whatever he receives, my lord, he forwards it to the government in the form of a comparative statement. And settling authority, it is the government. So deputy commissioner has no special role. So it is the circle officer. Now, this is the certificate, my lord, which was issued by the circle officer. That is why, my lord, they have neither made circle officer Matia a party nor annexed this document. Kindly see, my lord. On the basis of field verification report submitted by concerned LRA of Matia Revenue Circle Matia, it is hereby certified that Pub Gwalpara Fishery Cooperative Society, that is the respondent number 8 society of Gwalpara, with registration number so and so, is at a distance of about 300 meters from 3B lower part Brahmaputra and 13 Rupanjali so and so fishery. So, my lord, the designated authority, that is the circle officer, has certified that the respondent number 8 society is at a distance of 300 meters from the fishery in question. Therefore, I am in neighborhood. So, prima facie, my lord, there is no difficulty. Now, please come to the settlement order. Now, this document they have not brought in. They have not made the circle officer a party. Now, let us, my lord, today lordships will go by which order? Page 67. As regards jurisdiction of fishery under Gwalpara district, the tender inviting authority as well as settlement authority did not find any defect in the neighborhood certificate issued by CO Motia under Gwalpara district, wide dated so and so. Lordship may check up, this is the same certificate, which certify that society is located within 300 meters of the fishery in question under Gwalpara district, as it was issued based on report of LRA of Circle Office in terms of clause 3 of the government notification dated 18/1/18. This gazette notification. Now let me read further. In this connection, settlement authority also took into consideration submission of the Secretary Pub Gwalpara Fishery Cooperative Society by representation dated 40/25 with a copy of the order of the Honorable High Court, wherein the Honorable Division Bench of the High Court dated so and so in writ appeal has been extensively discussed, but particularly para 27 on neighborhood issue relating to one fishery under Gwalpara district having dual jurisdiction under Gwalpara and Bongaigaon district. The operative part of the judgment, white para 27, is quoted below. It is therefore held that it is beyond the purview of the Assam fishery rule to restrict the definition of neighborhood only to territorial limits of any particular district, excluding the participation of the fishing societies who are situated within vicinity of the concerned fishery, but within the territorial limits of any neighboring revenue district. In case of Pub Gwalpara Fishery Cooperative Society, in connection with settlement of the instant fishery, it is seen that fishery originates from Kamrup district and ends in Gwalpara district after crossing Borpeta district. It is obvious that in view of the order observation of the Honorable High Court quoted above on neighborhood issue, the quantum of area of fishery falling within district is irrelevant. Now, my lord, before I articulate my argument, let me place one more thing, Lord. Please come to the NIT for a moment. I'll make my final submissions on that. The NIT is at page 27. My learned friend referred to this clause 2, Miller. At page 28. Quotation can only be submitted by cooperative societies, self-help groups, NGOs formed by 100% SC community and actual fishermen belonging to Maimal community of Borab district. Now this is important. Bidders must be resident of the concerned district and also neighboring people of the Meen Mahal. Now, who can be a bidder? Whosoever is in the neighborhood of the fishery, no matter to how many district, how many subdivision, how many circle miller, the fishery extends. Now, petitioner's case is that fishery is confined to 2 districts. And we belong to Gwalpara district. Therefore, how come our cases were considered? But the settling authority is of the opinion that it spreads across 3 districts. Now, today, how can your lordship take a final call? So, if the fishery is spread across 3 districts, then the settlement order is absolutely fine, because otherwise I am giving much more revenue. My quote is, my lord, in page, if your lordship would kindly come to page 9 of the writ petition. Page 9, serial number 2 is the respondent number 8. Our bid is 3 crore 57 lakhs. And my lord, the petitioner's bid is only 2 crore 33 lakhs. And my lord, my learned friend has given a wrong statement regarding 3. They are the 3rd highest bidder. They are not defective.
Settlement order, it is defective.
No.
Yes.
No, we have the hearing.
Yes.
No, we have this, my lord, what do we call it? Comparative statement. It clearly shows.
But third in the order, it is 66.
And,
The third has
my lord,
the
that is not an
possibility.
issue. That is not an issue.
Invalid.
Now, therefore, and my lord, let us now articulate my points. Now, there, my learned friend is relying on the judgment of the High Court. If I have understood correctly, my lord, that judgment is an authority for the proposition that neighborhood is an expression which is not defined in so many words in the fishery rules. However, my lord, there are quite a few judgments where the legal connotation of neighborhood has been delineated. Now, from that, what is discernible is that you cannot measure it by inches or feet or meter or distance. The purport of neighborhood is whosoever is in the neighborhood of the fishery, they are all eligible persons. The distance has got nothing to do. Now, what was my learned friend defended that case, Miller? Today, I am in the same position when learned friend was there in the earlier case.
No.
Yes, it was appellant was
I
Mr.
didn't
M.K.
show
Chaudhary.
I know.
Kindly come to the case. No, I am going by the records. I was not there in the case. Now kindly come to me, Lord. Why this judgment supports us, I'll tell you. Tell your lordship. Yes. Yes, please come to page 84. Now, Mr. M.K. Chaudhary appeared for the appellant in this case, my lord. What was his argument? Same argument my learned friend is advancing today. See, please see, para 17. It is strenuously urged by appellant for consideration of the court that neighborhood of the fishery as mentioned in clause 2 of the notice will only mean neighborhood of the fishery within the district of Gwalpara as NIT is issued by Go. Same is the case here. My learned friend says the fishery is confined to Kamrup and Borpata. Therefore, a person from Gwalpara cannot. Same is the argument which was rejected. How can my learned friend rely on this judgment? The decision is an authority for what it decides. What was decided in this case is neighborhood, when it comes to a fishery which crosses through different districts, then everybody whosoever is in the neighborhood are all, competent to take part in the settlement process. Now, my lord, state has clearly come up with the finding in the impugn order that this fishery passes through 3 districts, contrary to the assertion of the petitioner that it passes to only 2 districts. Therefore, lordship has to decide. So today, where is the question? Otherwise, I am higher bidder. Otherwise, there is no infirmity as far as I am concerned. If tomorrow lordship comes to the conclusion that this fishery is confined to only 2 districts, a different view may be possible to be taken. But today it is not possible. So this decision is not an authority which supports the petitioner. This judgment is an authority which supports what we are trying to protect. Because it was rejected. This contention was rejected. Because their case was that here is a fishery which people from Gwalpara alone is eligible, others are not eligible. Well, the clear finding has been recorded. Please come to page 67 for a moment, Milord. Last but one para. In case of Gwalpara Fishery Cooperative Society, in connection with settlement of instance fishery, it is seen that fishery is originating from Kamrup district, ends in Gwalpara district after crossing Borpeta. It is obvious that in view of the order, observation of the Honorable High Court, quoted above, on neighborhood issue, quantum of area of fishery falling within district is irrelevant. This is what has been held. So what is wrong in it, Miller? Why stay order, Miller? What point has been made out to grant a stay order? On the contrary, my lord, this is absolutely right order. Today, my lord, lordships cannot take a call because their case is confined. And my lord, this fishery was lying fast since November 2023. So, my lord, they are proceeding on one basis. Government has come to a different conclusion. And most importantly, my lord, this certificate has to be challenged. Entire basis of this settlement is this certificate. This is not under challenge. This circle officer's thing has to be challenged. Entire thing is based on this. So therefore, my lord, we'll file our affidavit. Lordship will fix a date after the Bihu vacation. Lordship will take a call. I don't think, my lord, it's a case where Lordship will pass any interim order because there is no case has been made out for passing any interim order.
I'll just give a reply to this. My lord, please look into it. The first is said that we are not concerned about the judgment of the neighborhood. That's the first. Second, he said that there is a notification issued on 18th of January 2018. I am holding this notification and he refers to number 2, neighborhood certificate. Kindly see that. Neighborhood certificate to be issued by the concerned revenue circle officers. Whether he is a concerned revenue circle officers, only against fishermen cooperative society, SHG NGO with clear indication and specific distance of a fisherman cooperative society, SHG NGO to the concerned fishery. If the fishery falls under more than one revenue circle, then such certificates are to be furnished by all such circle officers. Now kindly look into at page 27. Whether circle officer Gwalpara was served this copy to him with this notice, kindly see. It was not necessary because that doesn't fall. He doesn't have to give a report. Kindly see. The District Commissioner of Borpeta for kind complaint necessary action. 2. The Circle Officer Nogorbera, Bagbor, Sengar Revenue Circle for information necessary action. These are all Borpeta district where it was addressed to the Circle Officer Gwalpara. This is what I am saying. This 18/1/2018 has to be consonant with number 2, who is the eligible person to issue a certificate. That indicates at page 27. So somebody from a circle officer where he has not been indicated, he is coming and he is giving a he is giving a report. Why I will challenge my learned friend, you have to challenge this. I am not agreed by his report. What I am agreed by a settlement order. I am agreed by a settlement order which has been passed. Maybe a CO. CO is not the, kindly see at page 27. 27, kindly see where it is marked. Only the report can be furnished by Circle Officer Nogarbera, Bhagbar and Sengar Revenue Circle. Matia was not given a notice that you give a report, we'll accept that. From where he has come? Who is he, my lord? The Circle Officer, the Matia. This is number one, first. Second, my lord, the judgment which my learned friend today, he said that I am in your side when you argued the matter. It is not. Kindly see what was the facts of that case. You have to look the facts of the case. Kindly see what was the facts. At my lord, see at paragraph 3 at page 71. Kindly see, sorry, 73 at paragraph 5. Mr. M.K. Chori, learned senior counsel, assisted by so and so, learned counsel for the appellant strenuously urged there is no infirmity in the settlement order dated 2012-2018 passed by official respondent. Learned senior counsel urged that a bare perusal or tender notice would reveal, my lord will kindly note down, that the participation in the bid process is restricted to resident of Gwalpara district only. That what we were agreed by. It was this, he says, that like here, my lord, if you lordship see the tender which was floated by Deputy Commissioner Kamrup, there also the Deputy Commissioner, my lord, Gwalpara has put the tender. We were under the neighborhood of Bongaigaon because fishery runs from Gwalpara to Bongaigaon. So that what we are agreed. He said that you don't have a locus because if you see the tender, it's a tendering authority is a Gwalpara. You belong to another district. Now kindly see, the term neighborhood of fishery will have to be understood in the context of the resident of the bidder and on the district in which the Competitive Society of Fishermen registered. At page 73, my lord. The learned senior submits that the appellant registered in the district of Gwalpara, whereas, my lord will kindly see, the response number 8 represents admittedly a society which is registered in the district of Bongaigaon. So it was, my lord, the whole case was of tender was floated by the Deputy Commissioner of Gwalpara. We said that no, we participated. He said, how can you participate? You cannot participate. Your tender is facilely floated by Deputy Commissioner of Gwalpara. I said that no, we are also a neighborhood because this fishery flows from Bongaigaon to Gwalpara to Bongaigaon. This is what the court decides. Okay. And 25 is absolutely clear. So one cannot ignore a judgment of a division bench. My learned friend says, no, you are the other side. This is what the fact says. You have to, the facts of the case has to be looked into it. So my humble submission before this court, as on date, there is no position has been taken. No position has been taken. So your lordship will kindly pass an order of status quo. No position is taken. So no irreparable loss or injury. If possession would have been taken, that's a different thing altogether. So let it be, my lord, status quo, or let it be state. And in the meantime, after view vacation, your lordship will hear it.
Hello,
that's my submission.
One point. My learned friend referred because the first time he said, so I have to give a reply. Page 27, he says, this was not marked to Circle Officer Motia. How can DC Kamrup mark him, my lord? As a Deputy Commissioner of Kamrup, he has got no jurisdiction. Then, my lord, why not to the Circle Officers of Bongaigaon district? Why it is not there? If we go by the petitioner's case that the fishery runs through Kamrup and Bongaigaon, then the Circle Officers of Bongaigaon districts also should have appeared here. So, my lord, that is how that is how, sorry, Borpeta. My learned friend says that this fishery starts from Kamrup and ends in Bongaigaon. Government says no, it starts in Kamrup, ends in Gwalpara. So government has proceeded on that basis. Now relying on 27, the contention is this was not marked to them. So where is the question of we making Motia a party? But settlement order is based on Motia Circle Officer's report. Page 66, they clearly refers to that certificate. Number one. And number two, my lord, if it was confined to Kamrup and Borpeta, then circle officers under the Borpeta should also have been indicated. Their name also do not appear here.
Have you taken over position?
Yes.
Where is
sorry?
Position, where is
No,
that
my lord,
position?
it's not a question of taking position or not. Question is, what is the prima facie case which has been made out by them? My lord, what is the case that has been made out by the petitioner? Their case is the fishery ends in Borpeta. Government says it ends in Gwalpara. If it ends in Gwalpara, what is wrong in it, my lord? Only when your lordships will record a finding that this ends in Borpeta, then only he will have a case. Today, how can your lordships come into that, my lord? Let us
Okay.
file our affidavit, my lord. We'll bring our
Mr.
facts.
Didas, Leonard Senior Counsel. Assisted by Mr.
K. Mohammed. K. Mohammed.
K. Mohanta. Mohammed. Learned counsel for the petition. Stop. Issue notice. Who appears? Fishery. Mr.
On behalf of Fishery.
Mr. P. Sharman, understanding counsel Fishery Department. And this appears on behalf of the respondents 1, 2, and 3.
And for number 4, 5.
Sir S. R. Barwal and government advocate for the respondents 4, 5, and 6. Stop. Extra copies. Petitioner to take steps for service of notice on the respond number 7. No. Mr. K. N. Chowdhury, senior counsel. You filed a caveat? No.
Yes.
Senior counsel. Assisted by Mr. S. Count. Enters appearance on behalf of respondent number 8 by filing caveat. Petitioner to take steps for service of notice on respondent number 7 by registered proceeding within 1 week from today. List the matter after 4 weeks. 4 weeks will have to be done because now notice have to go on 7. Or if you want to take dusty service, I can permit you.
I will take.
Okay, so on say within 1 week from today. Additionally, the petitioner is also permitted to cause service of notice on the respondent number 7 by dusty service to the registry of this court within 1 week, within a period of 1 week. Stop. Thereafter, petitioner shall file an affidavit to that effect. Stop. Then after 2 weeks, list the matter after 2 weeks.
Not on 21st, I'll be not there, Miller. Any other day.
I'm just saying 2 weeks. Or you want a date fixed?
No, it's okay, fine.
Oh, for 2 weeks. Stop. The settlement of where is that fishery name?
Miller, number 3, part B.
Your lordship will find the settlement order itself.
Yeah.
At page 66.
Miller, number 3B, lower part Brahmaputra fishery.
At page 66.
C within bracket capital B.
Okay, yeah. The settlement of 3B lower part Brahmaputra and 13.
No, not 13, not later part. Miller. Only first part.
No, 3B lower part and 13. No, no.
Okay, common.
Common
Sorry, I'm sorry.
And Rupsa Jali. Huh? Kola Banda fishery. That you'll find in page 66. Made in favor of the respondent number 8 shall be subject to the outcome of this week.
Diploma.
Will be subject to further order of this court, my lord, because if that is the case, then they will subject to further, they will take the possession, then a whole thing goes, my lord. It is for 7 years. Fishery, we have seen. Status quo as on today said, they have not taken possession. Status quo as on today said.
Status quo as on
Today shall you maintain, if they have
be difficult.
status quo as on today, will shall you maintain, my lord.
Let it be subject to the outcome of the
Subject to
petition.
further, let it be subject to further orders of this court, and your lordship fix on 21st. 21st, subject to
Okay, then
further,
list the matter on 21st.
subject to further order of this court.
Subject to further order.
Oh, yes.
Hello, 21st, I have submitted.
sorry.
Sir. Let it be 22nd, 23rd, any day.
Okay, 22nd.
Yes.
Huh? कब है? 23rd or 24th, any day, 23rd.
You have some difficulty
Yes,
on
22nd.
Okay, give a convenient date, both of you.
23rd, 23rd.
23rd is over.
23rd.
2 of production list. Susmita.
Just
Saikya
one
alias
second, I
Susmita
just
Das.
troubling you lot, one matter where my learned friend is there in this case, you will see matter.
Supplementary.
Can it be after
24, 24.
verification?
Is a consensus,
Yes.
is it a consensus?
I
date?
appear for ONGC in this.
Who is it?
Okay, on request made by the parties. You want date, no dates, list after Bihu vacation, or you want a date?
23rd, 23rd, 23rd.
23rd. I think his other matter is also fixed on 23rd.
I'm, yes, one. Deeply obliged, sir.
23rd, sir.
2 of production list. Susmita Saikya alias Susmita Das.
I'm sorry for traveling in Lordship. At least I made this approach. Mother, I operate, I have license. The admitted facts are, rather put it this way. I have IMFL on license as well as the country spirit license off, order of licenses. Now in my earlier place where I used to operate, some difficulties had come. So I had prayed under the rules for shifting from place A to place B. My application at page 23. I would not trouble your lordship with that, just indicating me at 23 for shifting. Now this triggers off an inquiry at page 25. An inquiry at page 25. I may like to read it if lordship permits me. With reference to the subject above, I have the honor to inform you that National Highway. Similarly, Susmita Saikya, IMFL off licensee bearing so-and-so, has already deposited the application fees of ₹2 lakhs, right so-and-so, treasury challan. During inquiry, it is affirmed that the above-mentioned licensee is in need of shifting her license from a present location as the landlord is not willing to renew the tenancy agreement. As per Assam Excise Rule 16, there is a provision for shifting of license premises from one place to another location under Rule so-and-so. I've personally visited the proposed site of Srimati Susmita Saikya, IMFL off licensee, and found that the area of the proposed site measuring about 336 square feet in, that is 24 inches so-and-so, on the ground floor of RCC building situated at Galapukri Road, Kachwagaon, standing on the land covered by DAG number so-and-so included in PP number 15. In this regard, above mentioned licensee has submitted a copy of the license IMFL and country spirit, copy of last year's renewal challan, copy of rent agreement of the proposed site, copy of Jamabandi, an up-to-date land revenue receipt and site plan of the proposed site, duly signed by the junior engineer of Tinsukia Development Authority, copy of NOC from Borburi Gaon Panchayat, NOC from local people, copy of existing trade license, copy of electricity bill of new premises, etc. There is no educational institution, public place of worship, and hospital within a distance of 150 meters radius from the proposed site. Hence, as per rule so-and-so of the excise rules, the shifting proposal of Srimati Susmita Saikya, IMFL off license, from its existing site to a new site may be recommended if the authority. So the inquiry is in my favor. I skip for a moment at page 27. Now the district commissioner writes to the commissioner of Excise Assam in favor. Second paragraph, if I may see. Second paragraph, this is on the 30th of November. The proposal was inquired into by the Inspector of Excise, Sadar Circle, and his report in the original, along with other relevant documents are enclosed herewith. The proposed site confirms to rule so-and-so. The licensee has deposited license shifting fee amounting to 2 lakhs. However, nothing adverse is found against the proposal, and hence the proposal is hereby recommended. Now the district commissioner recommends. 28. It comes to the Commissioner of Excise Assam.
Yes.
With reference to the above, I have the honor to convey herewith the approval for shifting of licensed premises of so-and-so to a new site at Galapukri Road so-and-so in the rented premises of so-and-so covered by DAG number so-and-so of the Assam Excise rules, subject to clearance of all outstanding liabilities, if any, against the licensee. My lord, license fees and renewal fees are for financial years. For the 24, I had to pay in March 24-25. which was already there. As the inspector report says, all fees is paid. For 25-26, the time is to be paid by 31st of March. Annexures H, H1 and H2 shows that 25-26 are cleared. That is 29, page 29, extreme right hand corner, Lordship has seen that manner. This is 2 lakhs, which I've paid. Next, Lordship takes up page 30. This is 20,000 and 31. That is 3 lakhs. The financial year is 25-26. Lordship is there. So last year also I have paid the coming this financial year, 1st of April, everything is cleared. All authorities up the ladder, up the rank at all levels have cleared. But the catch is, they're not allowing me to operate. If everything is clear, all documentation are clear, the inquiry is clear, the proposals are clear, the sanctions are clear, everything is allowed. Yet, it is extremely arbitrary and irrational on their part.
No, what do you mean by they are not allowing you to operate?
To open my shop. Everything is clear. Since January 9th
the
of
shifting was permitted.
shifting was permitted because my license is valid. Shifting was permitted. My fees was paid way earlier. Everything was there. Only from place A to place B, I needed a fresh sanction, approval, whatsoever, permission from them. This took some time. And by 9th of January 2025, that was cleared. My renewal fee was paid till 31st of March earlier. Now, this 31st of March, I paid for this financial year. So that has nothing to do. So even I understand that 9th of January, they put things off hold, although say, okay, everything is cleared. But now 31st March has gone. Even now, they're not allowing me to open up at the new place, although there is nothing against me. But there's a move afoot, which I could come to know. They are planning to cancel or suspend because they're not allowing me to operate. It's a case when there is no order against me, nothing on record against me. Every authority has allowed district commissioner, the tax person, the commissioner concerned, judicial authority, everyone is allowed. But they're still not allowing me to operate. I've paid all the money.
Yes, protocol.
I'll take instructions while the date maybe fixed. I'll get these.
When do you want?
Before vacation, I'll
Next week.
end of the next week.
Till then, don't take any coercive steps against the petitioner.
How did you fix on 10th, Minu?
Whatever it is.
Whatever,
up
because
to
it is sometime. I would pay earlier.
Bhanik, Learned Counsel for the petition. Mr. I. Bhatapur, Learned Standing Counsel, Excise Department. Press for a short time to enable him to receive instructions. Press a lot. List on 10th.
10th.
Why not? There is a respondent number 2 also. Their instruction may also be required.
Who's 2? Okay. Then say like this. Mr. I. Bhatapur, Standing Counsel Excise Department, as well as MSU Das, additional senior governor for the respond number 2. 2 and 3. Press for some time to enable them to receive instructions. Press on not less than 10 until the next date. No coercive step be taken against.
Obliged. For motion, Mina. Might not be pleased to indicate.
Coming for motion.
For motion. Obliged.
I'm not issuing notice.
Very well. Grateful.
9 of daily list.
May please. Lordship, respondent may file affidavit of opposition, Lordship. Lordship, petitioner may be allowed to file reply, Lordship.
What was this matter about?
My lord was.
I vaguely remember.
Yes, my lord. Page 54 of the affidavit in opposition, my lord. Inquiry report. The last paragraph, my lord.
1 minute.
Page 54.
Page 54.
My lord, the inquiry report.
Okay.
Lordship, petitioner supplied for 3 circle officer.
Okay, let him file his reply. Let us.
Lordship. 2 times.
Mr.
Yes, my Lordship.
Learned Counsel for the petitioner prays for how much time?
2 weeks time, Lord.
2 weeks time to file reply to the counter affidavit filed by the respondent number 2 to 6. No, filed by the respondent number 1.
My lord.
Question number. Response number 2, Lordship. 2 at 226, Lordship.
No, 226 by the respondent number 1, it says.
Lordship. Response.
By the respondents. Oh. Where's the list of the 2 weeks?
Deeply.
11 and 12.
Well, in last occasion, the Lordship has given a last chance to file the affidavit by the respondent number 5. My Lord, these things has not come till today. So, my Lord, I have taken the consent of the my Lord, Indian Water Transport Department advocate. So, this matter is a very urgency because 2 years, my Lord, lease period, it is 1 year already expired, my Lord. So, this matter will finally heard and for disposing on 22 April, my Lord, after the vacation, my Lord. And by this time, if they require to file, otherwise, I am not insisting on them.
Yes, my lord, as per my lord, last order is my lord last chance, but my lord, though I am not taking that plea, my lord, that only last time, my lord, the extra copies was served and I will have sent for my lord, the instruction, my lord, and I will receive it, my lord,
Okay,
by
my Lord.
tomorrow or my lord day after.
Okay, my Lord, let them file.
No, so my lord,
Okay.
22, my Lord, that should be fixed, my Lord, for final disposal. By this time, they will file the affidavit. My Lord, I am not finding any reply if it is not required. My Lord.
that, my lord, that
That may be, my Lord.
It's on your request, you want it listed on 22nd.
No, because I want the final disposal. And that's
So
because-
you want it on,
Yes, my Lord.
on request made by B. Mahanda, Leonard Council.
With the consent of the, my Lord, the standing council inland water, my Lord.
And also with the consent of the Leonard Standing Council.
It may come as consent of all the parties.
Maybe, my Lord.
that is not
Okay,
our
just-
Yes,
consent
ma'am.
actually, my lord,
Uh,
because I am to file affidavit.
No, by this time, we can file, no
on
problem.
request made by P. Mahanda, Leonard Council. List on 22nd April. 22nd.
22nd April, my Lord. For final disposal, my Lord. That's what
Oh.
is reflected.
Don't say like this.
My lord.
Heard P. Mahanda, Leonard Council population. Also heard order. MST, you does learn additional senior government advocate for the
For
respondent.
5, my lord.
For 5.
Happening 4.
I don't.
How about the private respondent?
Yes, my Lord, he is also.
Okay. Transport department, Mr. Then it's Standing Council Transport for the respondents.
123.
123. And Mr. V. Kotakil and the council for the respondent number 4. And also use this list of matter on 22nd for final disposal. In the meantime, respondent number 5 may
Fine.
file.
My Lord, my Lord.
Okay.
Deeply obliged.
Well,
Or we can finish these 2 items. 13 and
13.
The matter of this case is regarding non-payment of contractual bill on my lord. And
I will update instruction regarding the validity of that contextual bill, validity of that project.
What instructions you have? Is
Earlier
it an admitted amount or you disputing the amount?
My lord, it's validity exhausted. Now that departmental financial committee meeting, that
You file your affidavit then. Mr. Hart P.K. Majumdar, Leonard Council for the petitioner. Mr.
P. Hazarika on
Leonard Council appearing on behalf of Mr. S.R. Raba, Leonard Standing Council, Soil Conservation Department is allowed. How much time?
2 weeks time.
2 weeks time to file contract.
the fixed date maybe.
Okay. 30 April.
Obliged.
14.
In this case, respondents have not filed their affidavit, Lordship.
In this case, we have received the proper instructions and will be filing.
Mr.
P. Sharma.
Leonard Council for the petitioner. I'll record Gogoi's name,
Yes,
Mr. B. Gogoi, Leonard Standing Council PWD submits that he has received instructions and press for.
Lordship may sit on 29. If possible, 29th of April.
It's for 2 weeks time to file contract. Released on 29th. Huh? Interim order partially to continue till the next sitting. Yes. Where is the BB Barwa?
16 to 19, my lord.
Yes.
My lord,
Where's your
order, yes, my lord, he's there. Can it be, my lord, on 24th, my lord, of April? Pension matter, my lord.
Heard Mr. BB
PP Burra is here.
learned counsel for the petitioner, as well as Mr. P. N. Chama, learned standing counsel,
Elementary Education Department.
Elementary Education Department. Please the matter on.
Lordship,
24th.
24th, difficult.
Due to paucity of time, this could not be taken up.
Only of the negotiation.
List down.
24th, my lord.
29th would have been convenient for me because 24th I have some difficulty.
29th.
Lordship. Okay.
Other councils? No.